We will call the meeting to order, and the first item is amendments to the agenda.
All right, so I have two requests for withdrawals. 825-0250 AB Williams Day and Community Concepts. And E24-0079 Sector P Convenient MD. I have terms for Ecker. I am waiting on the withdrawal, but that just settled on Friday night, and I anticipate having the withdrawal in a couple of weeks. For Williams versus Day, I have the withdrawal form and the terms. So I recommend that you approve both of those. And then where's H25-0346 A, B, and C Morrill versus Saco Falls Management. Thibodeau and Racine complainant has requested a right to sue letter. And since the effect of a right to sue letter is effectively the same as what we would be giving her as the closure documents, I'm going to recommend that as well. So I would need a motion
Right, so,
for all of those.
Move to approve the withdrawal of E2479 and H25250, and effectively the withdrawal of H25346.
Effectively, but can you say issuance of a right to live? Just because it's going to make a difference.
Reported the way I intended.
Thank you, Ed.
Not good for that.
Okay. Moved and seconded. Any discussion? Okay, seeing none, the motion is to allow two withdrawals and the issuance of a right to sue. Pursuant to the Commission's remote participation policy, the commissioners will indicate their votes visually and audibly. If you were in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Oh, we can't hear you, Meg. I'm not sure if that's on.
How about now? Can you hear me now?
Try again.
Can you hear me now?
Hold on, let me put the volumes down.
What about now?
There we go.
Ah,
Okay.
perfect.
So already on our
Yes.
end, but down.
Yes, that's my vote.
All right.
Thanks.
So that takes 3 cases off the agenda. We can proceed with your usual script. If you were here as counsel for any of those cases or as a party in any of those cases, you are free to leave now. We will send a letter to everybody confirming those withdrawals once we have them, and the right to sue letter will be sent to the complainant and CC to the respondent in Morrill versus.
So we need to update the agenda now that we've amended.
Yes.
Move that we adopt the proposed amended agenda. Second.
Moved and seconded. Any discussion? Seeing none, if you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Yes.
And next, the minutes.
And the minutes are. I'll move that we accept the minutes as written.
Now you can sign.
Within 5 minutes as promised.
Yeah.
Right on the nose.
So, yeah, moved and seconded. Any discussion on the motion to adopt the minutes?
This is the minutes of the March meeting. Now I reviewed them.
All right. Okay, if you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Everybody?
The minutes. Adopting the March minutes.
Yes.
Thank you. Commissioner Sanders?
Yes.
Yeah, okay. So for director's reports, personnel, Jillian Pion, who I'm not sure any of you have met. This is Jillian.
No, it seems like.
Jillian has been one of the front office secretary associate legals for a year, almost 2 years. And was just promoted to business manager, which is the position that Chelsea was in before, so yay. And she was shadowing Jane because she will be taking tech. Great, so Jane doesn't have to run tech and present case. For compliance, sorry, Megan's texting me, that in a second. We have 4 cases in active conciliation and 2 unsuccessful conciliations. I have no agreements for you to approve, so that's easy. For investigation, we had 41 new complaints, 59 total respondents, 34 dismissals, 10 administrative dismissals, 7 right to sue requests, and 6 cases that were withdrawn with no benefits to the complainant. For predetermination settlements, we had 11, 1 through private settlement, 4 through our mediation program, and 6 settled while they were in investigation for a total of $273,334 to complainants. For the quarterly reports.
Well,
Yes.
the case numbers, that's exactly the same as last month, isn't it? 7 new cases for investigation.
41.
Yeah, but isn't it 41 less the 30 that are gone?
No, those were 41 new complaints that were filed.
Right.
And then 34 cases, different cases.
Oh, okay.
That
Well, that's
were
what's
dismissed.
confusing.
Yeah.
They're different cases.
Yeah. Yeah.
But still, that's the average input.
It's pretty, we usually have somewhere between, I would say, 40 and 60 complaints per month.
Okay.
What is the average caseload for each investigator?
It varies, but it's usually, I would say, between 20 to 30 at any given time. You can see actually in our pending inventory reports, we have a total of 600 cases currently open. That's cases, not respondents. An average age of 290 days, which is great. Cases that are in processing, which means that we are still waiting for some initial pleading, either the respondents answer the complainant's reply. We have 179. Again, that's total cases, not total respondents. So if there was a case with multiple respondents, I've only counted that once. An average age for those cases of 71 days. And the total cases with investigators is 220. So divided by how many investigators do we have, James? 5. Somebody do the math and that will give you Jane. 5 plus Jane.
Is it 5?
I say 5.5 because Jane is doing half admin, half investigative.
Yeah, it's 5 plus me.
It's actually an average of about 40 cases per investigator, which is higher than it's been for a long time. Well, I'll take this, I'll talk about that in a minute. Let me finish this one. So total cases with investigators, 220, with an average age of 183 days. I think that is actually the average time since they've been assigned to the investigator. So that's still, we're doing very well on those numbers. I uploaded the wrong training and outreach report. That is the one that you had the last time for the second quarter. I have now uploaded the correct one to the Google Drive. If you want to go back and look at it, we had a pretty slow first quarter, not unusual for the end of winter. Nobody is doing anything, but we had 10 events that staff either participated in or attended. And you have a quarterly financial report. And if you have questions about that, please ask
Michael, what does it mean? Everybody.
Everything for us looks good at the moment. Our issue, once again, is receiving our federal funding.
Yep.
If that doesn't happen, then we will be in trouble in the next year or two.
Yeah, and no further word on that?
But at the moment, we look good. Kit, any further word?
Yeah. So the good news is that our budget initiatives did get into the supplemental budget, which means that 4 of our positions that were split between one of our federal funds and the general fund have been moved entirely into the general fund, which will free up some federal dollars for us going forward. once that budget goes into effect, because we will no longer be pulling that money from either the HUD account or the EEOC account. It will all be in the general fund. So that will give us some more sort of, that extends the time that we have before our federal funds run out. And I'm hoping that it extends it enough that I can now post for an investigator, one of the two that is currently open, and anticipate having funds to at least pay them for a couple of years before I have to figure something else out. On the federal side of things, I have submitted a voucher to the EEOC for the $49,000 that they guaranteed us in our contract. We should have that in the next month. I still have no word on whether they will be appropriating any additional funds for the cases that we have contracted with them to investigate. We've already closed more cases than that $49,000 covers. So,
But they haven't paid it yet.
they have not. And it's typical that we would voucher for about 25% of our cases once we have closed them, and then voucher for the rest of it at the end of the contract year. The difference this year is that usually the contract that I get from the EEOC says, we've contracted with you to close X number of cases, and here's how much we'll pay you for them. And this year what I got is, we will pay you $49,000, we promise. The rest of it, if and when funds become available, and they have not approved the number of cases I told them I think we can close. So I have no idea how many cases they're planning to pay us for, or if they will in fact pay us for any of them. But $49,000 is not nothing. I'll take it. On the HUD side of things, we spoke last meeting about the multi-state lawsuit that has been filed against HUD in regards to the guidance that all of the agencies around the country got who have work sharing agreements with HUD, based on our perceived, there are issues with that guidance with regards to both its constitutionality and its compliance with the Administrative Procedures Act. So there's a lawsuit about that. We had received a voucher from HUD for payment for all of the work that we did in the last fiscal year. That voucher referenced the guidance in ways that would have sort of taken us out of the lawsuit. So we've joined the lawsuit and then went to sign the voucher and realized that HUD had pulled the vouchers after the lawsuit had been filed. I still had the PDF version, so I signed it and sent it in anyway, and we're not the only agency that did that. But we have had no communication from HUD at all, even on basic issues, except maybe you have spoken to, no. We haven't heard from the guy who accepts or rejects cases for dual filing. I haven't heard anything from the guy above him, who is who I talk to when I have questions about HUD stuff. I haven't heard from anybody at the Fair Housing Enforcement Office about the voucher or about anything else. So I think that there will be conversations about that between the AGs who are leading the multi-state litigation and DOJ, who is representing HUD, but right now I have no update on that.
Okay.
We'll see.
Question from Michael. When I look at that quarterly report, and I keep, every month I try to learn a little more about it. My question is, if you go to the bottom right-hand corner and you get to 36.19%, is it naive for me to conclude that that's good because that's through 3 quarters, that anything above 25% means we're sound?
It is not naive for you to believe
It's
that.
correct.
And you are right. And that's what I look at. I look at anything above 25% is good.
Okay.
I also look at each individual column to see if there's anything below 25%. And you will see that there is something below 25% in the first column. And Kit and I are currently addressing that.
Under general funds?
Yeah. For some reason, they did not budget enough in our general fund to pay for our salary expenses for the year. I don't know why.
Well,
if we need
flip it all.
Right. If we need to move money from one of the federal funds, we can, but we're in discussions with the budget office about why this has happened first, because our federal funds, as we know, are limited. And I would prefer to not spend them on something that we should have had the budget for.
If any of our federal funds looked really bad and the general fund looked really bad at the moment, we'd be very concerned.
So.
But for this fiscal year, we're fine.
And we start a new one July 1st.
That's right.
Thank you. So Kit, anything else for?
No, I'd say that we take litigation and executive session.
Yeah.
I guess for new business, just briefly, there's a public hearing tomorrow at Judiciary on the referendum that will be on the ballot in November about sports and sex-segregated facilities. We will be presenting testimony, but because we only found out about the public hearing on Friday, I have not written it yet. So I will be doing that this afternoon.
Is it the wording? Is it about the wording?
There will be stuff about the wording. It's my understanding, I should be more familiar with the referendum process than I am. It is my understanding that any referendum gets a public hearing because the legislature has some things. They might decide to put forward a competing measure. They might decide to adopt it as law. But I am sure that there will be testimony about the wording, because the wording also only came out on last Tuesday.
I didn't see the wording.
Yeah, it's on the Secretary of State with it.
Nobody's happy with it?
Oh, then she must have done a good job.
Exactly, go Shanna.
I think it's fine, but there will be testimony on that. The wording is on the Secretary of State's website if we want to.
Okay, we're
All right.
at our time. We'll go into the hearing agenda. So, good morning. My name is Ed David. On behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking that each of you who may have an electronic device, cell phone, pager, etc., to ensure that they're silenced. We have additional agendas, including the consent agenda online and available here in the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time, and the commission has voted on those cases, then they will not be considered further today. The remaining cases on the agenda today, as amended, are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in the order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium or recognized online to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one relevant factual errors, two relevant omissions from the report of facts submitted during the investigation, or three relevant issues and questions concerning the interpretation of law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that commissioners may ask questions, and I will ask that you introduce yourself as you are recognized. The first case for hearing is E24-0065, Antonio Russo versus Allied Universal. The recommendation by the investigator is for the commission to find no reasonable grounds on both counts. The allegations were discrimination on age and disability. The recommendation being for no reasonable grounds, we would therefore hear from the complainant first. And Kit has instructions in the presentation.
Yes. So just a reminder to everyone who is participating today, the commission's confidentiality provisions, statutory and the rule require that you not use the name of any third party or entity. Basically, you can use the names of the people who were named as parties to the complaint, Otherwise, the investigator has used pseudonyms in the report, and we would ask that you please use those and not refer to anybody's name. I am looking for either Mr. Russo or Attorney Morris.
Here.
Ah, okay, Mr. Russo.
Yes.
Great. You have 10 minutes. Do you want to, people often reserve some of that time to respond to the opposing party's presentation? No? Come up to the podium.
Kit, before the complainant begins his presentation, I need to assess whether I may have a conflict in this matter. Mr. Russo, are you represented by counsel in this matter? I understand that your attorney may not be here today, but I can't see the room itself, so I'm curious about your status of counsel.
Not here, May.
Excuse me?
I don't have anybody here today.
Okay. Are you otherwise represented by counsel, however?
I will be. No, I am not at this point.
Okay, so just wanted to make sure on the record, I think I heard you say that you are not presently, as of today, represented by counsel. Is that correct?
That's correct.
Okay, thank you.
So you're all set to participate, Matt?
Yes, I am.
Okay.
All right. Whenever you're ready, you can go.
Okay, I'm responding to the investigator's report that I don't believe the facts are correct. That was the answers provided by Allied. The first one was the performance issues. They said that I was removed because of performance issue, and that is false. They said that I was removed from the Jetport on March 15th of 2020, and that is false. I actually put in a request for a leave of absence on March 21st, 2020, because I was being treated for cancer. They said, company said they investigate. I complained in my notebook. I have over 60 complaints that myself and other security officers filed. We did follow protocol. We talked to the officers in charge and got no response. So we wrote letters. I wrote the letters, and they participated to the Jetport, the regional office, and the national office. The national office said they never received the letter. However, I was not hired back at one time because the supervisor said, we can't hire you back because you wrote the letter. So obviously somebody got the letter. When whoever did the investigations into my complaint and found that it was could not substantiate it, I asked who did the investigation, who did they talk to, what questions did they ask, and they refused to answer. I have several witnesses that will testify that all the complaints are in fact legitimate. They also said that when I was hired back in 2023, I neglected to mention that I'd been removed from the Jetport for the Vaseline incident. That was not true. Also, the human resources person actually called the New Hampshire regional office while I was there and got permission to not only hire me back, but to place me back at the Jetport. They used the Jetport Vaseline incident as the reason they've removed me from the Jetport in 2023. The Vaseline incident did occur. I did put Vaseline on some door handles. Sometimes the job was getting boring, and the sky caps would come in and leave their pizza boxes, fry bags, everything in our office. We have a little cubicle with 2 desks, and they would leave them there. And then the cleaners started coming in and taking our desk and chairs and putting them out in the lobby. Okay, we're old guys, we're all retired professional people, and we warned them. We said, if you keep doing this, we're going to get even. Well, I was the one that got even. I put the Vaseline on it, and I got caught. And my boss called me in, and he said, "Do they want Vaseline?" I said, "It's greasy," and yes, I did it. So he said, "Well, the Jetport wants me to suspend you for a week or 2 without pay." I explained what happened. He went up and talked to the Jetport personnel. He came down and said, and I quote, there'll be no punishment, no disciplinary action, and no more practical jokes. So that was that, but in 2023, they used that incident as one of two reasons that I was being removed. The other one was I was sitting there with Steve, my supervisor, in the arrivals area of the jet port, and the cleaning guy had a really good system for changing trash cans, which may sound small, but I appreciated it. So I said to my supervisor, Steve, just watch that guy. He's got a really good system. And the guy was 30 feet away, and he said, "Are you talking about me?" And I said, "Yes. I saw my boss that you've got a really good system." And he stared at us for like 15 seconds. And then he said, "Why don't you just go F yourself?" And he turned around and walked away. And my boss said, "What just happened?" I said, "I don't know." He said, "I'm going to get coffee. Do you want one?" And I said, "Yes." Now, who made who feel uncomfortable? I was complimenting the guy, and he told us something quite unpleasant. Let's see what else was there. Oh, it says an email from a supervisor showed that he was first told by the previous site supervisor that he had been removed. Well, the supervisor that told him that was the same supervisor that on 3 different occasions slid me. He was the supervisor of Allied. Can I say Allied?
Yes, you may third party.
Allied. And on 3 different occasions, he slid me resignation forms. Once when I complained that one of the supervisors was having an affair with one of the officers. Another time when I complained that sky caps were smoking marijuana in the parking garage. And the third time was when 2 of the supervisors, we had a young man who had Asperger's, who was a great kid, still is. And they teased him so badly that they made him cry to go home. So I spoke up and said, I'm going to file a complaint with the ADA if you keep doing that. And he gave me a resignation form. Now, coincidentally, he left Allied and went to work. He's now the supervisor of the cleaning company, who the cleaning guy that told me to go F myself went and told him, and that got back to the Jetport. So I think both of those things played heavily on me getting removed from the Jetport. The other thing was when I first filed a complaint, and I'm a little unclear on this, the first attorney I talked to that was listed on the MHRC website told me that because they were using the 2020 Vaseline incident as cause for my removal, that I would be allowed to use all my notes and all the instances and discrimination issues that had taken place between 2015 and 2020. So that's pretty much it. I think that Allied's responses are, for the most part, incorrect, and I think it should be reconsidered. Thank you for your time.
Commissioner, questions for Mr. Russo?
I'm a little deaf too, so if she doesn't speak up, I got my hearing aids in, I still can't hear.
All right, seeing none, I will have, oh, yep.
Mr. Russo, can you, your complaint says you're alleging unlawful discrimination on the basis of age and
Yes,
disability. Are you pointing to specific facts
yes,
that tie it to age?
yes.
What are those?
I have in my notes that I listed in the letter that there were 4 new supervisors. I owned a company, I owned a restaurant company, and one of my other senior officers was a line officer for the Portland Fire Department. And we're more than qualified, and they were hiring people off the street to be supervisors, and we trained them. And 2 out of 6 supervisors, 4 of them told me that Corey Nason, who was captain at the time, I'm sorry.
That's fine.
The captain at the time told them that I was too old and too slow to be a supervisor. And every one of those people would make I've got all the comments. I keep copious notes. And I've got notes where they said to me, "You'll never be a supervisor. You're too old. You're too slow. Why don't you try to keep up?" Several notes like that. On the the ADA violation, I was in need of a hip replacement. They said I used the cane afterwards. I used it before. The Jetport actually gave me the cane to use, and the captain said either use it or go home, or lose it or go home. Now, he let another officer use a cane when he needed it. So I believe he did an ADA violation. The last one was the whistleblower.
This is a supervisor saying you can't use the cane
He told me I couldn't use it, but he let a friend of his who was,
in your job as a security
yes,
guard, right?
yes. Yes, the cane that the Jetport gave me to use because they saw I was in so much pain. But he also let another officer use the cane when he needed it. So the last one was the whistleblower. They claimed they didn't get a letter, but Corey told me, the captain told me he couldn't hire me back because I wrote the letter. And I also, Allied said they never received the letter, but I have a UPS receipt that shows that I did send the letter. And I have copies of the letters in my notes.
A letter saying what?
That all the violations that were taking place. I have the handbook here, and there's about 47 to 60 complaints of handbook violation that we reported. At that time, the captain was kind of not enforcing any rules. They've since lost the account, by the way, due to, I don't know why, but they've lost it.
And there was discussion about reassigning you, and the investigator says you never contacted them back.
I contacted them and I said, why would I want to?
Explain to me what the issue there was.
I was removed from the airport on May 15th, I believe it was, 2023. And they said, go home and we'll call you. They didn't call me.
The subcontractor, your boss, saying they would reassign you to someplace other than the airport?
Yes, Allied. And we never got together. I was going back and forth to Michigan. My son having some issues. And I kept coming back and they wouldn't hire me. And then I said, why should I leave here? I haven't done anything. Well, you did the Vaseline. No, I didn't. I mean, I did the Vaseline, but that was 2020. This is 2023. It was resolved. Well, you made that guy feel uncomfortable. He swore at me. I didn't swear at him. I said, I complimented him. And I said, I want to stay at the Jetport. I know the Jetport. It's comfortable. I mean, I'm 80 years old. I don't want to walk on concrete floors that handle it. I believe that was the site that they were going to send me to, and you'd walk, 6 or 7 miles at night on a concrete floor, and I don't think I could do it. So, thank you. You're welcome. Thank you.
Any other questions for Mr. Russo? Seeing none, you have about 2 minutes and 50 seconds left after the respondent presents theirs. So you can sit.
Thank you.
You want. Yep. Okay. And we're not attorney couple. I apologize. Classes are failing me. Ms. Kalamia, I apologize if I'm not pronouncing that correctly.
Not a problem. Good morning, and good morning to the commission. My name is Jennifer Calamia from Martinson, Hasbrook, and Simon for Allied Universal. Just to briefly respond to Mr. Russo's points. First, and it cannot be overstated, while Mr. Russo was removed from the Portland Jetport site, he remains, even to date, eligible for rehire. Should Mr. Russo wish to return to work at an Allied Universal site other than the Jetport, not only did his prior supervisor initiate attempts and consistently follow up with him via email in an attempt to place him at a different site, but Allied Universal remains willing to do so. There's nothing barring Mr. Russo at this juncture today from becoming an Allied Universal employee again and returning to work. First, Mr. Russo claimed that his performance issues, which are the basis for his 2020 termination, were false. To the extent that there may be a blanket sort of a characterization of the issues for which Mr. Russo was removed in 2020, Allied Universal acknowledges that it was the Vaseline on the door handles incident that resulted in Mr. Russo's removal from the site at that time. Just to explain a bit of the process, Allied Universal is a security company. They enter into contracts with various sites and they place security professionals at those sites, such as the Portland Jetport. And so, while we understand that Mr. Russo may have had a conversation with his supervisor in which the supervisor didn't think that the doorknob incident was very serious, unfortunately, the Portland Jetport did. As an airport, airports maintain some of the highest levels of security, rightfully so. And so, while Mr. Russo's removal was inevitable due to the incident, he at that time still remained eligible for rehire, which is how regrettably he was rehired in 2023 at the same site. To the extent that Mr. Russo states that he requested a leave of absence in 2020, that is correct. However, Mr. Russo was first told on March 15th, 2020, that he was being removed from the Portland Jetport, specifically due to the door handle incident. Now, Mr. Russo thereafter, rather than seek alternate assignment with Allied Universal, chose to take a voluntary leave of absence, which, again, Allied does not dispute. And to the extent that, Mr. Russo claims that he got permission, that someone received permission to rehire him in 2023, unfortunately, the site rehire, due to a change in managerial personnel, Mr. Russo's application slipped through the cracks, and the managerial personnel did not initially realize that he had been removed from the site. But again, the supervisor worked with Mr. Russo on various occasions, and the Allied Universal has submitted various emails that were exchanged between them. The final contact between Mr. Russo and a manager was on August 28th, 2023, where the manager wrote, quote, "As I stated in my previous emails, when you have returned to Maine, feel free to reach out to me and we can discuss what sites I have available at that time." And Mr. Russo did not do so, which is the only reason that he has not been placed at an Allied Universal site to date. To the extent that Mr. Russo claims that he engaged in protected activity or an issue with a cane, all of those incidents occurred in 2020 and are outside the statute of limitations for this case. And this concludes Allied Universal's rebuttal, unless the commission has any specific questions that I can answer.
Commissioner Douglas.
Yes, Attorney Calamia, good morning.
Good morning.
So, yeah, I'm just trying to get my ducks in a row on the retaliation claim, right? And I'm looking at the investigative report, and there's some confusion about this letter that complainant says he wrote in March of 2020. And the report says of detailed unprofessional behavior at the site, including alleged disability and age discrimination, and that you folks deny receiving any letter. So what I'd like to know is your perspective, what's in the record regarding this letter, whether it was received, et cetera.
Absolutely. Allied Universal has no record of receiving the letter. However, during the investigation of this complaint before the commission today, Allied Universal was able to confirm that Mr. Russo did make verbal complaints, which Allied Universal believes in sum and substance could have contained some of the complaints in the letter. Allied does believe that Mr. Russo complained about workplace misconduct. However, that doesn't change Allied Universal's position. First, that incident is unrelated to the 2023 removal, especially given that any of the supervisors in 2023 who made decisions regarding Mr. Russo's removal had no knowledge of such complaints. So even if Mr. Russo were intending to link those complaints to his 2023 removal, no one in 2023 had knowledge of those complaints. In 2020, they may have. However, that doesn't change Allied's position that that's not the reason that Mr. Russo was removed and that he remained eligible at all times for rehire.
Okay, so these late discovered verbal complaints that complainant may have made, just want to make sure I understand this. They were discovered in 2023, and they are distinct from the complaints set forth in the investigative report where it says the complainant reported misconduct by other staff members on many occasions, and those were investigated and found to not have merit. So there's a separate threat, is what you're saying.
Yes, that's correct.
Okay. But your position is regardless, I mean, you would have him, I guess what I'm wondering is the other sites, right? If it's in the record, are there any sites close by to the Jetport where he could have worked? It's not in the record?
Yeah, sorry.
Okay, well, I'm hearing that's not in the record, so I guess I'll withdraw that question. All right, thank you.
Thank you, Commissioner.
Any further question for Respondents' Council? Seeing none, you'll have about 5 minutes and 20 seconds. Mr. Russo, you have 2 minutes and 50 seconds if there's anything else you'd like to add.
Okay. I have copies of the 2 letters that I wrote and sent to Allied. The interesting fact is that the Vaseline incident took place 6 months or so before I put in for a request for leave of absence because I had cancer. In 23, I did not take a voluntary leave of absence. I was trying to determine whether I could get back to the Jetport, basically, and that's because where I wanted to do. But it doesn't, and I know she said, the attorney said the time frame had expired, but I need a clarification on that because they used the Vaseline incident in 2020. Does that reset the clock on everything, or are they only ones that can use 2020 as a reason? I do have copies of the letters. I don't have an attorney as yet, but I was fortunate enough to work for a fairly large firm out of Columbus, Ohio, Porter, Morris, and Arthur. And I did talk to one of the principals last week, and they're working to get me, the attorney that I have been using is a small attorney. He doesn't do contingency cases. The attorney I talked to in Porter, Morris, and Arthur is going to try to get me an attorney that will take it on a contingency basis should I file a civil suit. The question that I had is the Jetport said they investigated the complaints I had, but I don't know who did the investigation. I don't know who they talked to, what questions they asked. I know who they didn't talk to. They didn't talk to me. They didn't talk to my fellow officers. They didn't talk to the retired chief, the police officer that I talked to. There's a retired supervisor from Allied that's willing to testify as to the legitimacy of my complaints. And that's the questions that I will be asking should it go further. Thank you. Thank you, ma'am. Sorry.
The letter that you say you have copies of and that you sent, is that in the record?
I'm not sure it's in Yorick. I sent it.
Yes.
It is?
Yeah.
Yeah.
Right, and so what does that letter say?
May I get it?
No, just tell me.
It just says that there's issues going on at the Jetport that need immediate addressing, several violations of company policy right in their own handbook.
So it's a letter detailing your disclosure of things that you think are improper.
Oh, yeah.
And so that's the basis of saying that you're terminated in retaliation for those complaints.
Yes. I was never terminated. I was removed from the Jetport. I wanted to go back to the Jetport, and there has been some communications and mix-ups, I guess, back and forth. But I think it ignores the fact that there was actual several instances of discrimination, age discrimination, ADA violations, whistleblower. The supervisor told me that me and another officer that we couldn't be hired back because we wrote the letters. And I have witnesses that will, testify to that under oath if need be.
Who do you say told you that?
Who told me that?
Yeah.
The captain
From Allied?
from Allied at the Jetport at the time when I went back to get my job back in after I had cancer treatments and COVID had come to pretty much an end, is when I went back and was told, you can't come back because you wrote the letter. And then in 23, there was a new captain there. I went to the HR person, Xavier Bosley. He called New Hampshire, the regional office, got permission to hire me back, place me at the Jetport. So when they say they weren't aware of it, maybe they weren't. Maybe Bosley didn't tell them. Maybe New Hampshire didn't tell them. Oop, I'm sorry. I mean,
I think you're answering what I want to ask. What is the obligation? What is the process of reapplying to come back to work after the leave and go back to the Jetport? They say that you failed to disclose that you'd previously been removed from the Jetport because of the
Vaseline incident.
Because of the Vaseline incident,
Right.
The practical joke.
Well,
Were you obligated to disclose that in some way on an application?
no, I did disclose it to the HR person, and he called New Hampshire, and
Is that in the record?
I don't know.
So, you can go ahead and answer the question. The record is very unclear, and I'm unclear based on the responses as to whether or not Mr. Russo is identifying port and Jetport employees. Sorry, probably 100% right. Or allied employees when referencing supervisors. So I will look in the record and I will try to answer clarifying questions.
I have not talked about Portland Jetport supervisors, all allied employees at the HR or supervisors.
And in terms of the attorney's statement that you remain eligible today to be placed at a site by Allied, you're saying that you don't want to if it's not the Jetport. That's what you want.
No, I don't want to go back to them.
You don't want to go back to Allied.
Right. I worked after I left Allied. I went to work for PSC, which is a security company. I worked at.
We would make sure this is in the record.
Oh, it's not in the record.
If it's not in the record, we can't.
Yeah, anything that happened post removal in terms of Mr. Russo's attempts to get other jobs or where he worked is not there.
Okay.
Okay.
But and again, I think that the statute of limitations is the issue here. I mean, we were discriminated, but there were 3 or 4 of us senior citizens that were passed up for promotion and we all had much better experiences than people they hired that lasted about 2 weeks or 3, I don't know. But they
What
just
lasted 2 or 3 weeks?
the new supervisors.
Oh.
We weren't qualified to be supervisors, yet we trained the new supervisors. And that was always ironic. One of the officers actually wrote a training manual. So I'm getting off target here. I think the whole basis is that they're focusing on why I was let go, why I are going back, and they're ignoring the fact that there was rampant discrimination going on throughout the time that we reported. I've got schedules, I've got times, dates, stamp dates and times, individuals, witnesses as to, the discrimination, the constant harassment. I was verbally and physically punched, verbally assaulted, physically punched by the supervisors, and they're saying it's okay to do because you're an old man. I'm Italian. I don't like to take that, but I did. I did not get any way back ever.
Commissioner Douglas.
Yes. So good morning. First of all, I have to tell you that I've been very careful to not leave the account of this case lying around my office. If any disgruntled paralegals are gonna put Vaseline on the knob. Can't happen. So the standard here is whether or not you show an even chance of prevailing at trial, right? And so as I'm listening to these presentations, I'm just struck by the fact that, I mean, your claim is basically that, you know, you raise these allegations of discrimination that are going on there, both against yourself and against others. And as a result, you've been removed from the jet port, right?
Yes.
And so let's say that you're able to credibly assert that at trial, right? I think the difficulty that you have is that, you know, these allied folks are gonna say, well, we were happy to have him. It was our client that didn't want him there, right? And we were ready to put him elsewhere. I mean, you told us today you didn't want to go anywhere else. You just wanted to go to the jet port. And so I guess what I'm wondering is, how are you going to explain that at trial? Like, how are you going to explain that they just didn't want you at the jet port, but they were willing to have you anywhere else? You see what I mean?
Yes, sir, I do. I think the answer is that it's still not addressing the discrimination issue. If I went back to another site, am I gonna have a special eye over me saying as soon as you get rid of him because he's a troublemaker? I don't know. There's a lot of supervisors, a lot of people in our industry, in that industry. I don't know. I think I'd be all around. I did work 3 years at a different site and got several, not for Allied, for another company. And I worked a lot of hours and was very well respected, and I get several, you know, references for that. But like I said, I'm 80 years old. Need to slow down a little bit. But again, I think my main concern here is that they ignored the letters. The lieutenant, the captain, just let the discrimination go on, and it was quite obvious. There are qualified people that will testify if this goes to a civil. And I was told by the attorney, the one that doesn't do contingency cases, that my options would be file a civil suit. And I think I have until May of 26 this year to file it, or go public, get that Channel 8, do 8 investigates. I turn over all my notes, all my papers, and give them a list of witnesses that would demonstrate that Allied really didn't enforce their own handbook. And I mentioned earlier, they just lost the account of checkbook. I don't know why, it's not my business, but you know, there was one instance where they.
I think we're getting a little bit.
Okay, I'm sorry. All right.
Thank you, sir. Right. I think you've answered my question.
Thank you.
Thank you.
Any other questions for Mr. Russo? Thank you very much.
Am I done?
You were all set,
Thank you.
yep. We'll move back to Respondents Council. You have 5 minutes and 20 seconds if there's anything else you'd like to add.
Thank you. I think that Allied Universal's position has been fully stated both in the record, you know, to the extent that Mr. Russo is concerned that another Allied site would carry some sort of cloud, or, you know, that his reputation would precede him. You know, Allied Universal submitted its policy handbook as part of the investigation, and it maintains a rigorous non-retaliation, non-harassment, and non-discrimination policy, which would, you know, be abided by in all instances. And unless there are other questions from the commission, I have nothing further at this time.
You're David.
Yeah, this business about the letter, you sort of dismissed the letter, which he says detailed other violations, which he has a right to bring to that attention. You dismiss that because you say Allied doesn't have any record of having gotten it, correct? Have you seen it? Is it in the record that you've now seen that what he alleges he sent?
What Mr. Russo, there are two categories of alleged letters. Allied Universal has now seen what Mr. Russo purports he sent in 2020, but it had no record of the letters at that time. It only had record of his verbal complaints. However, over the course of this investigation, Mr. Russo claims that he sent a letter to Allied Universal in May of 2023. However, the only letter that he provided over the course of this investigation was an email to an attorney seeking legal assistance after his employment ended. In 2023, Allied Universal recognizes that Mr. Russo claims he sent some letter, but Allied has no record of any letter in 2023.
Yeah, it's not introduced by him in the hearing and in the record. You're saying the only thing that's in the record since 2023 is an email.
Correct.
Okay. Thank you.
Any other commissioner questions? Yes, Commissioner Dunn.
Yeah, just briefly, your position at trial is going to be that regardless of what you receive from Mr. Russo, whether it was, a letter alleging discrimination, all the complaints that were or were not investigated as we discussed your last go round, your position is going to be that he was not discriminated against in terms of being removed from the Jetport by you. It was your client, the Jetport, that wanted him not to work there. Am I correct about that?
Yes, that's correct.
Okay, thank you.
Any other commissioner questions or respondents counsel? Seeing none, thank you very much. We've heard from the parties, and next we'll hear from Jane O'Reilly, the investigator assigned.
Good morning, commissioners. So I'll start by saying I'm going to do my best. The timeline in this case is a bit confusing, in part because there are some contradictions in terms of what complainant said he had evidence of or said occurred when, and what's actually been presented in the record. But regardless of all of that, I think my investigation focused on what's important in this case is the causation link. So my investigation, the report that I wrote, doesn't dispute that complainant made protected reports. There's definitely enough evidence to suggest, certainly by our standards and probably more than that, the complainant was reporting what he believed was violations of policy, which may or may not, rise to the level of illegal activity, certain like uniform violations, things like that. But also, as he stated today, allegations of disability discrimination against an employee who had a disability, comments about age discrimination, or comments about age of employees, as well as allegations that older employees weren't being offered the same promotions, things like that. However, there was nothing to connect that with either the removal in 2020 or the rehire and removal in 2023. So, that was ongoing during his employment. But the stated reason for his removal in 2020 was this incident with the Vaseline on the doorknobs. And then he was actually rehired at that location because of, new supervisors changeover in staff, unaware. And there's evidence in the record, an email exchange from employees at the client location where he was and Allied that indicate through the investigation of this other incident with an employee where there was, again, not clear what the interaction was, who was offensive, who wasn't offensive, not relevant to the determination that during that investigation, they discovered that he had been previously removed, wanted to know why, determined it was an unprofessional incident. And it was that combined with the fact that he hadn't disclosed it, whether or not he had an obligation to disclose that he had worked there previously and been removed. He had an interview where he did not bring that up. And the supervisor who made the decision to remove him so he didn't want them from working anymore at the client location, felt that that was unprofessional behavior in and of itself, that he didn't disclose that he had been previously removed for this conduct. So the causation link between his removal in 2023 and any protected activity that occurred in 2020 was not established by what was provided on the record. Any questions?
So none of those reports that he says he made, that you say that if he made them, there would have been protective reports. None of those are made after 2023?
No, they were all made prior to his removal in 2020. Then he did go on leave. He was, and then he was rehired when he came back to work at the same location.
The only thing that sort of bothers me is does the client have the right to tell Allied they don't want them for discriminatory reasons?
So,
They would not, right? And they would be subject to the act?
so,
They're not named.
Right, so the client is,
That's right.
right, the client isn't named, so whether or not the client's was reason that they gave Allied was pretext. I can confirm that the reason they gave Allied was the Vaseline incident. They didn't say to Allied, we want this guy gone because he made protected reports. They said he engaged in this conduct, we don't want him here. But whether or not that was pretext and they would not have fired him, would not have asked for his removal from that location based on his protected report is not part of this record because that party is not named in this complaint. So Allied's conduct is all that was being investigated, and Allied had a legitimate non-discriminatory reason that. And again, they didn't engage in an adverse job employment action beyond confirming the clients.
Does he have a cause of action against?
I can't answer that.
that's not sure, that can't.
And I,
Good answer.
Sing party?
I mean,
you know,
that's,
Complainant's case, he named who.
yeah.
You named who he named.
Yeah. So that,
Boy, that's
and to the extent that complainant, you know, I will clear up the sort of timeline issue to the extent that complainant is saying the door was opened on this past conduct. As you'll see in footnote 1 of my report, it's relevant. It's relevant information because of what happened later, the fact that they removed him in 2023 based on what happened in 2020. But any allegation of conduct that occurred then would be time barred based on when he filed his complaint.
Right. Okay. Thank you.
Want to be crystal clear about
Mhm.
this. So what your investigation found was that complainant was removed from the site, not from the job, by the client, by the Jetport. And as far as what I'm hearing you say is that you did not see anything to indicate that it was Allied that removed complainant for all these reports that he made.
Correct, but I'll also point out that if there was a claim based on that removal in 2020, that would be time. That's untimely. So what we're really looking at is when he was rehired in 2023 under a different supervisor. All that supervisor knew was that he had been discharged based on whatever record they had. So he's looking at Allied's record. This is going to be confusing. Okay, so you know, to the extent that we're trying to connect back to a discriminatory reason, let's say, for example, the client removed him for a discriminatory reason and gave Allied a pretextual one, non-discriminatory one. It's the Vaseline incident, which really was discriminatory. That happened in 2020. Then when he's rehired, the supervisor at the client location who says, I want him moved again, he didn't know about that when he rehired him. What he learns is what Allied told him, which is that he's been removed. He was removed in the past and what his supervisors told him at the client location. So he's learning this guy was removed for a Vaseline incident, and that's why he removes him again. So you have two breakdowns. You have two breakdowns in causal connection, because at that point, he's being removed based on what was reported about the removal in 2020. Does that make sense?
No, it all makes sense.
Okay. So, you know, there just wasn't a link between what happened in 2023, the timely adverse action, and what was going on.
Right. Client is not named in this.
Right.
So again, I'm just trying to confirm that the reason why he was removed from the Jetport was due to the client's complaint.
Client's request.
And is it your, you know, was it your finding consistent with what Allied's counsel said that they would place Mr. Russo at a different location if he asked?
Yes, so the correspondence that was read by Respondent's Counsel, Allied's Counsel today, the email that says, reach out to me when you, that's the last email I have on the record as well. He was emailing Allied and saying, I'm gonna be back in the state on this date. And they said, okay, let us know. Then he would email again and push that date back. Then he emailed again and pushed that date back. And then finally they reached out and said, you set a couple of dates that you're gonna be back. Just let me know when you're here. Give me a call when you're in the state. We'll find a place for you. And he did not respond to that email.
Thank you.
Okay. Any other questions? Thank you very much.
At this point, we are looking for a motion. There is one proposed finding. Two proposed findings?
Two.
Yeah.
I think there are two proposed findings.
Right, undisclosed number.
They're on two different pages, and that's why I didn't.
First
There
one,
are,
it says-
there are two
It's hidden by a
proposed
footnote.
findings. Yes. All right.
Now that we got that straight. So I will move that we take these together and we find that there are no reasonable grounds to believe that Allied discriminated against Mr. Russo and based on age and or disability, and there are no reasonable grounds to believe that Allied retaliated against Mr. Russo for engaging in MHRA and or WPA protected activity.
Second.
Moved and seconded. Any discussion?
I just want to say that to Mr. Russo, I'm sympathetic to some of the things that went on too long ago to be cognizable now. And I think we sort of missed the boat in terms of who you were alleging was discriminating. I believe you that you sent the letter, but it's clear that those were allegations of conduct prior to 2023. So I think we're constrained to say that that Allied did not unlawfully discriminate against you. Somebody else may have. You make an excellent presentation, sir. But I'm going to support the motion to find no unlawful.
I just want to echo that, Mr. Russo, and I want to say that to the extent you were reporting age and disability related discrimination, et cetera, we appreciate that. Well, unfortunately, we're constrained by the bounds of the Maine Human Rights Act and the law and what we can do here today. And based on that, I don't think you stated a claim, unfortunately.
Any further discussion? Okay, seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
So the findings are no reasonable grounds. We appreciate the party's participation, and the commission will send a letter regarding next steps.
One quick question. Do I still have the right to file a civil suit?
Yes, the letter that you get from the commission will give you a timeline.
Thank you for your time.
Can we take 5 seconds?
Sure. We'll be in recess for 5 minutes. Second case is PA 2468 A and B. Randy Stokes versus St. Joseph's Hospital and its internal medicine practice. The recommendation is for finding on the single count of that we make a finding of no reasonable grounds. Therefore, we will hear from complainant.
Ms. Stokes-Reed? You have 10 minutes. Do you want to save any of your time to respond to the respondent's position?
Yes.
How much time would you like to say?
Probably just a couple minutes, if that's okay. And do they have the copy of what I provided?
They do.
Okay.
They have the report and your submission of disagreement.
Okay, thank you.
If I can tell, I'm gonna have to ask you to speak loudly, please.
Oh, okay, I will. Sorry. And I have light sensitivity, so I have to leave my glasses on. Thank you. Okay. Good morning. My name is Brandy Stokes-Reed, and I am the complainant in this matter. This case comes down to a few simple questions. First, did the investigator apply the correct standard? At this stage, the commission is not supposed to decide who is right. The question is whether there is at least an even chance that discrimination could be found, but the report does not do that. It resolves disputed issues in the respondent's favor, like whether my treatment was individualized and whether my accommodation was reasonable. Those are factual questions that should not be decided at this stage. Second, was this really individualized medical judgment? The report treats this as a disagreement with the provider, but the record shows something very different. It shows structured prescribing programs, including the Controlled Substance Stewardship Program, with thresholds, review triggers, and standardized tapering practices. That raises a real question about whether my treatment was based on individualized care or policies and programs. The training materials matter here. These training materials include a cast of characters that categorize chronic pain patients into types based on assumed behaviors and responses to treatment. They group chronic pain patients into categories and assumptions. They treat patients as a population to be managed under standardized frameworks rather than individualized, requiring individualized medical care. When that kind of thinking is applied to a disabled patient asking for reasonable accommodation, it raises a serious question about whether individualized judgment, I feel like I'm only looking at one of you.
Yeah.
I'm just looking at you. It raises a serious question about whether individualized judgment was replaced by stereotyping or policy-driven assumptions. These materials also reflect an approach in which decisions are driven by population-level outcomes. The record reflects that these programs were evaluated based on the idea that a majority of patients could be tapered successfully, which the correct number is 77%. But that also means a significant portion of patients would not do well under those approaches, which was 23%, which is what I am. I'm part of that 23%. The training materials themselves acknowledge that the majority of patients will do just as well, which necessarily recognizes that some patients will not. The question in my case is whether I was treated as an individualized patient with complex medical needs or as part of that generalized population. That is directly relevant to whether individualized assessment occurred and whether my need for a reasonable accommodation was meaningfully considered. And these decisions did not occur in isolation. The record reflects a broader environment where prescribing decisions were shaped by institutional programs, oversight structures, and monitoring systems designed to reduce controlled substances use. These systems create strong pressure on providers to conform to standardized practices, including concern about regulatory scrutiny and potential professional consequences if they don't. When decisions are made within that kind of environment, it raises a legitimate question as to whether individualized medical judgment was influenced by external pressures rather than focused solely on the needs of the patient. Third, was my disability accommodation actually considered? This is not just a disagreement about treatment. I asked for a reasonable accommodation. Disability law requires individualized assessment and reasonable modification when needed. The question is simple. Was my need for continued treatment meaningfully considered in light of my disability? The report does not answer that question. Fourth, were guidelines treated as rules instead of guidance? The decision relies heavily on prescribing thresholds, but federal authorities have made clear those are not rigid rules or laws, especially for stable long-term legacy patients, which is what I was and am. My case is exactly the kind of situation those warnings were meant to address. Finally, what actually happened to me? I was stable for many years on my treatment regimen. I had no evidence of misuse. I was able to raise 3 sons, run a successful tutoring business, and live independently despite multiple serious medical conditions and high impact intractable pain. Then that treatment was taken away under these policies and programs. I experienced severe decline and catastrophic medical harm. I lost all mobility. I've lost all independence and my ability to physically function. Despite clear warnings and documented harm, my request for accommodation was denied and the involuntary forced taper continued. I also have documented malabsorption, which requires individualized treatment by multiple providers in multiple states. That is exactly why individualized assessment matters. The question before the commission is not whether respondents are right. The question is whether there is enough evidence that discrimination could be found, and there clearly is. There are factual disputes. There is evidence of policy-driven and programs decision-making. There is evidence of stereotyping, and there is evidence that accommodation was not properly considered. That is more than enough to proceed. I respectfully ask the commission to reject the findings of no reasonable grounds and allow this case to move forward. Thank you.
Commissioner question, please. Commissioner Ryan.
Because you were looking just at me. Just one thing. Where did you get the 77% can be tapered effectively? Where's that from?
So the respondents were partners with a sitting Board of Medicine member, Dr. Nesson, which is in the record.
But please don't use their name.
Oh, I'm sorry. Okay. A sitting Board of Licensure member. He piloted the Controlled Substance Stewardship Program against patients with substance abuse and mental health issues. And he was successful with 77% of those patients.
Okay, is that state or federal?
State.
Okay. Thank you.
Commissioner Ryan.
Yes, good morning.
Hi.
So first, I appreciate your presentation. It seems like you put a lot of work into this and all the sort of policy arguments that you have. I very much appreciated that. And you correctly cited the standard for a Maine Human Rights Commission case, whether or not there's an even chance to prevail at trial, right? So that's kind of what I'm thinking about right now. And I'm wondering, as I'm listening to you talk, I'm trying to think about how it's going to play out at trial, right? So in particular, this Dr. Quirion, if I'm pronouncing that right, is going to take the stand and say that she reviewed your dosage level, right? And she found it to be excessive. And it says here in the report, there was a risk of death. If she considered, and I understand you don't agree, you don't need to make that point to me again. But I guess what I'm wondering is, she's going to make those points. And I understand you since found somebody to put you back where you were in terms of your dosage, right? But I think that the question is going to be for her at trial, right? If I'm cross-examining her, if I'm representing you, I'm wondering, how am I going to prove that what she said is not well within the guidelines and the practice standards for her in terms of her conclusions. Do you know what I mean? I think you're going to need expert testimony for that. And so I'm just wondering, what is your take on that today? Like, how are you going to, I understand the discrimination arguments. You don't need to rehash all those for me.
Mm-hmm.
But in terms of proving that this isn't just based on, medical practice standards,
Mm-hmm.
do you have any thoughts on how you're going to prove that at trial?
All I have to do is show exhibits of me on my stable regimen, able to walk. All of the exhibits are there. When they started involuntary forced tapering me, I had severe bloody noses. My spine fractured and collapsed. The exhibits speak for themselves. You can see it in the pictures of, and Dr. Quirion, again, the respondents are partners with a sitting board of medicine licensure member. They ran these programs. It's programs and policies. We didn't have a choice. No one has a choice. You don't get no one on opiates. So not even just legacy patients were all on high doses. I have to take high doses of all of my medication for them to be effective because I have malabsorption and Crohn's disease. Again, that's why it was important for individualized assessment. That's not what happened here. I didn't have a choice. They already had it determined that they were going to do this forced taper. And when catastrophic harm began to happen, they refused to stop it. So to answer your question, I can let the exhibits speak for themselves. You can see me thriving and physically functioning with my stable regimen. And when they took it away, you can see catastrophic harm happen.
Right. And I understand that's your case. And I'm not here to argue with you or to say that is going to work or that's not going to work. All I'm saying is that this doctor is going to take the stand at trial. I'm putting something in your head for you to consider.
No, I understand. And I appreciate that. And I do have expert witnesses and testimony.
Okay. Because this doctor is going to take the stand and say, it doesn't matter whether or not she was stable on her prior regimen, right? It was excessive and it created a risk of death and I couldn't do it. And that's my medical judgment based on my years of training and expertise and so on and so forth. And I think that's going to be your hurdle at trial.
Appreciate it.
Yeah, Commissioner.
You agree that you need to show that there was discrimination against you because of your disability.
Correct.
And you're making the argument that all the studies and stuff that she's citing about tapering are the reason that she didn't treat you individually, that she treated you as a member of this population that ought to be tapered, correct?
Right. She's running the program. She and the hospital are running the controlled substance stewardship program.
Okay, and the report says that the doctor told you that she believed complainant's prior dosage was bad prescribing and her reason for tapering you was purely because of the risks posed to your health. So the investigator is saying that that's what the doctor is saying, that it was indeed individualized treatment and that she prescribes higher doses in different situations, like palliative care and that kind of thing. So you need to prove that she's not treating you based on your condition, that she's only treating you because of the statistic of a class that you're in.
Right, but I'm not the only one this happened to. I'm a legacy patient. So that's what they did. They targeted legacy patients on high doses of opiates and to force them off of their medication. based on our pain, our severe intractable pain. The FDA and the CDC came out and said, no, you can't do that. No abrupt tapering or discontinuation.
Sounds like you want the Maine Human Rights Commission to jump right into that battle and make a finding that those prescriptions about overprescribing and tapering are wrong. And we can't do that.
No, that's not what I'm asking.
It feels like it.
No, I'm not asking that.
Okay.
What I'm saying is that I was on a stable, long-term regimen by multiple medical providers in Boston, in Maine, in Montana, because I have extenuating circumstances.
This provider.
Because they dragged all of my providers in front of the board and prevented them from seeing me or served them with cease and desist letters.
I don't understand.
It is a coordinated, what happened to us was a coordinated effort, which is all in the record. I've stated exactly what happened to me and my medical providers. I had 3 medical providers dragged in front of the board of nurses and licensure. None of them lost their medical license. And I had my former.
The report says that her determination, the doctors, regarding your care were based on her medical experience, medical research, and guidance. Right? And you're saying that that's
not true. I'm saying that she is running the Controlled Substance Stewardship Program. They founded the Schmidt Institute and CCSME. So they are running these programs and forcing patients and medical providers into their Schmidt Institute, their Controlled Substance Stewardship Program, and their CCSME classes. So they're the judge, jury, and the executioners, and that is wrong. It is discrimination, and it is not individualized medical assessment.
Any other questions for complainant? You'll have about 3 minutes when we come back to you.
Thank you.
Move to Rebeen. We cannot see you or hear you currently.
How's that?
Great.
Good morning, commissioners. Go ahead.
You want to reserve any of your time?
I will be very brief and reserve some time, yes.
Okay.
Good morning, commissioners. I'm Heidi Bean. I represent the respondents to this complaint, all of whom are healthcare practitioners. I'm happy to answer your questions. The respondents disagree with the complainant's recitation of facts in certain respects, and I'm happy to point those out to you. But one of the respondents to this complaint declined to prescribe opioid therapy that exceeded the allowable limits under Maine law. The treatment was provided in accordance and in compliance with Maine law. There is no policy in place at any of these providers that prevented the complainant from receiving medication. The decision was due to her medical provider's judgment. I ask the commission not to second guess the healthcare provider's medical judgment in this discrimination claim. The complainant seeks to change a provider's treatment rather than gain access to treatment. And we disagree that there was a denial of medical services on account of the complainant's disabilities. She has pointed out she claims that there was no individualized treatment here, but the clinician did in fact prepare a 58-week taper specifically for this complainant. The complainant did not complete the 58-week taper, but it was prepared for her specifically. When the nurse practitioner, Eva Quirion, who is a nurse practitioner, not an MD, Eva has a PhD and she's been practicing care of chronic pain patients for longer than 17 years. When she met the complainant was not walking. She could not mobilize. She was in a wheelchair and her shoulders were down around her knees. So we will dispute her description of her condition on her prior pain regimen. I'm happy to answer questions, but I will reserve the rest for to respond to further comments. Yes, sir. Yes, sir.
Okay.
Oh,
Commissioner Davis and then Commissioner O'Brien.
Okay. Good morning.
Good
Looking at my
morning.
calendar, whose hand went up first?
So I heard you say that the prescription by your client was limited by Maine law, right? There are limits prescribed by Maine law, and that's what your client complied with. And I'm wondering, how are you going to, at trial, square that with the fact that her treatment by your clients appears to be bookended by two providers who prescribed, apparently, based on your description, more than the legal limit, right? The previous provider, and then she went and found somebody else to get her back up to that level that your client was not willing to prescribe her at.
I believe that at trial, the respondents will say that they did not lower the complainant's prescription precipitously. They implemented a 58-week taper under a compassionate taper exemption to the prescribing laws to get her towards compliance with Maine state law. So she would, over that 58, longer than a year period, she would be moving towards compliance. And during that time period, she would be exempt from prescribing limits because she would have a compassionate taper exemption to the law.
Right. Okay. But she, the complainant alleges basically what amounts to a conspiracy of sorts, right, whereby her opiates are going to be limited, right? And I'm not trying to get into an argument with you, Attorney Bean. I'm just wondering, isn't that a problem for you at trial? I'm just thinking about the witness list, right? For her, witness number one is the previous prescriber who says that she's at this level for a period of whatever, right? Witness number two is your lady who says, we're going to do this compassionate taper that you described. Witness number three is the subsequent provider that says, oh, we can bring her back up to where she was before. In light of all that, in light of the sort of conspiracy alleged by a complainant and the even chance standard, I just wanted to give you a chance to respond to that.
I don't think that this can be viewed as from purely a discrimination for your human rights issue. This is a medical standard of care issue as well. And I anticipate that at trial, there will be evidence that the plan created and implemented by these clinicians was consistent with good medical care. And I absolutely acknowledge that the complainant disagrees with what good medical care was, but I am confident that there will be evidence at trial that this treatment plan was consistent with the standard of care.
Right. And so your theory, it doesn't really matter so much what the other providers did. The question is whether or not your client you know, her actions were consistent with the applicable medical standard of care. There could be a deviation, but the question is whether your client's actions were consistent. Isn't that right?
That is, yes, that's correct.
Okay. All right. Thank you.
Thank you. Commissioner O'Brien?
Okay.
I didn't forget you.
Thank you. So when you say the allowable standard, the allowable level, dosing level, I think you said that is state law. And I'm not, could you explain that? Not so sure.
There is a main, I wish I had it right in front of me, but the Maine state law prohibits prescribing on over a 100 morphine milligram equivalents per day unless the patient meets certain exemptions. And those exemptions include metastatic cancer, they include palliative care, which addresses a patient who is near death and has intractable near-death pain. So there are a number of exemptions to the 100 morphine milligram equivalents prescribing limitation, but this complainant does not she doesn't meet any of the requirements for one of these exemptions. And although she was prescribed a taper under a palliative compassionate taper exemption, that is for a prescribed period of time. It's not forever. And the 58 weeks was prescribed under a compassionate taper under an exemption, but it cannot go forever.
Okay, for now, thank you.
Thank you.
Any other commissioner questions for Attorney Bean? Commissioner Sanders.
Thank you, Attorney Bean. I, of course, listened to the presentation. I read the investigator's report. From my perspective, this seems like a very simple set of circumstances. Factually, I understand the complainant is deeply distressed with the medical decision-making here and certainly has our sympathies to the extent she is articulating suffering as a result. That said, though, the facts seem straightforward to me and you know, from my perspective, again, clearly support your client's position. So, you know, running through the facts that we have here, again, keeping it very simple, I just want to run through those with you to make sure that I understand exactly what they are. We know the complainant in this case established care, right, with NP Quirion in this case. We know that the nurse practitioner worked with the complainant to understand her health conditions, to understand the prior prescribing. We understand here that based upon the nurse practitioner's independent professional judgment, understanding the evolution in the standard of care here with the treatment of and the prescribing of opioids, right? And in coordination with this internal controlled substances stewardship committee, Ms. Quirion landed on an independent medical assessment that the current prescribing that the complainant was accessing, quote, posed a significant risk of death, right? We know that that's in the record. We also know that it's in the record, and I heard you note just now too, that based upon all the facts and circumstances, the health history, the prior prescribing, understanding the evolution in changes in the standard of care, understanding what Maine law currently reflects, and also understanding too, right, that the complainant's prior providers ran afoul of the licensing board associated with that prior prescribing NP Quarian implemented a compassionate taper, right, that was individualized according to the complainant's health needs. And that taper was scheduled to take place over the course of 52 weeks, right? So over the course of roughly a year.
Correct. Yes.
To address sort of what needed to happen in this particular case. So I guess I'm struggling to the extent that complainant, takes exception to the medical decision making here, and even understanding too, reasonable practitioners, right, reasonable providers can disagree and still all meet applicable standards of care. Isn't it? It's not simple, but given the facts I ran through, isn't it just that simple, right? That we should adopt the report of the investigator and find no reasonable grounds.
I would encourage and ask that the commission do that. I agree with you that reasonable practitioners can disagree on reasonable treatment. But I cannot endorse the treatment provided outside of the window that my respondents were
Sure.
involved in. And so, but I mean, any healthcare practitioner gets to choose who they treat. And if the patient cannot disagrees with the treatment plan, they can't. My clients were not going to negotiate a treatment plan with the complainant. They had one in place, and she disagreed with it. I will not suggest that it would have been easy for the complainant to find someone else to prescribe at the on the schedule that she preferred, but it was not discrimination for the respondents to create and implement a treatment plan that represented a compassionate taper.
Thank you.
Commissioner O'Brien. Thank you. Thank you. Could you explain what happens when opioids at a certain level are prescribed? Are the prescribers, hospital nurse practitioner, doctors, are they under scrutiny? Are they looked at? Are they punished or scrutinized in some way specifically if they, I mean, how can I? Yeah, are they scrutinized, I guess, specifically?
There is the main the prescription monitoring program is monitors both prescribers and patients as to their prescribing of controlled medications and their use of controlled medications. There are sometimes clinicians come to the attention of their licensing boards because of some anomalies in their prescribing patterns as demonstrated on the prescription monitoring program. So yes, but as far as a situation where a pain management specialist is compassionately tapering a patient through a taper plan, that is not the type of thing that would come to would show up as an anomaly on the prescription monitoring program, or the PMP as it's called.
I guess that's why, I think that's my point. If they're tapering, it doesn't rise to the level that no one is looking at them very closely and any, not punishment, but again, scrutiny. But if they're not in that 52-week compassionate tapering deal, they are looked at very, very closely. Am I right in that?
If the analysts who run the PMP, the prescription monitoring program, see anomalies in filling prescriptions or in writing prescriptions for controlled substances, they can flag those. I mean, and there are, and I won't pretend to understand exactly what causes a flag like that, but you know, opioid prescriptions are they're usually very short term, 14 days or 7 days, and they are usually time limited. So if a prescriber pops up that they've been prescribing for longer periods or higher doses, that might be a flag. But again, I'm not an analyst for the program, but I do know that certain things trigger review.
Thank you. Any other commissioner questions for Attorney B? Seeing none, we'll come back to Ms. Stokes-Reed. We have about 3 minutes left.
I'd like, I drank this, I'm sorry, yeah, trash. I'd like to address the palliative care. Palliative care is specialized medical care focused on providing relief from the symptoms, pain, and stress of a serious illness, regardless of the diagnosis or stage, not strictly for end of life. In 2017, I partnered with Senator Jeffrey Gratwick. He created an exception bill, and I had to go testify in front of the state legislatures. They said that I already qualified for palliative care and can go over the 100 MME restricting limit. Quirion could have used exemption code B, palliative care, for me. I have multi-system disease. And again, palliative care is not for end of life anymore. That's not what it's for. So, and yes, the prescription drug monitoring program is being used as a surveillance tool. So they have made it to where you get alerts if an opiate and or a benzodiazepine prescription is filled in Maine, they get alerts and they drag those providers in front of the Board of Licensure. That is what is happening. I have to go outside of Maine. I have to go to Massachusetts now because they have shut down these medications for patients who need these medications. You know, we didn't cause the overdose crisis or deaths. There was no misuse. I passed all of my urine screens, my pill counts. I passed everything. And I did what I was supposed to do. And they're punishing the wrong people. So, you know, Maine is shut down. And that's not right. That is discrimination. I shouldn't have to travel outside of my state to receive medical care or prescriptions.
Any commissioner questions for Ms. Stokes? Commissioner Walker.
You did a very articulate job with your presentations.
Thank you.
How long were you on the prescribed medication treatment prior to this change?
Over a decade.
And I'm assuming from how you've presented that you certainly didn't request a change.
I wasn't given a choice.
Yeah.
I went in and they already had the involuntary forced tapering done. I mean, they had it done. I didn't have a choice. They had no alternative treatment modalities. So they're taking me off of my pain medication. I'm just suffering. I'm in agony, and I'm not the only one. It's all legacy patients. So
for the 10 years or more that you were already on a treatment, was it also through St. Joseph's?
No, it was not through St. Joseph's, but I had specialists at St. Joseph's. So I go to wound care. I went to wound care at St. Joseph's. I had providers there that knew that I was on my medication, and they approved of it and supported it.
Thank you. Senator Gatwick was a doctor
Yes.
from Bangor.
Yeah.
Thank you.
Thanks. Any other questions for Ms. Stokes-Reed? Thank you very much.
Thank you.
And we will hear again from Attorney Bean. You have about 7 minutes left if there's anything else you'd like to address.
Thank you. I would just like to highlight for the commission members the exemptions that were applied in complainant's case. The nurse practitioner used exemption code B, which is, as complainant points out, the serious illness exemption, and she used exemption code G, which allowed her to use a taper longer than 6 months, because from complainant's starting point, the nurse practitioner did not believe that it was reasonable to try and taper her within the 6-month requirement of the law. The serious illness exemption code B is not a permanent exemption. It is not. It's not. So that there were 2 exemptions applicable for the palliative taper, the serious illness and the longer than 6 months taper were applied in this case. Thank you.
Commissioner questions for Attorney Bean? Seeing none, we've heard from the parties, and next we'll hear from Jane O'Reilly, investigator assigned.
Morning, commissioners. So I think I'll just start by talking about the timeline again as well. I think there were some things that were not in my report that I didn't find relevant to my finding, but have been asked about here, sort of the treatment that complainant was experiencing before she came to St. Joseph's. So, and there's been some questions about the sort of monitoring system, like what happens to doctors if they're overprescribing, things like that. So some of what respondent's attorney was presenting about that, I don't think is in the record, but what is in the record is that complainant could no longer get her prescriptions from her prior provider because her prior provider's license was under review for his prescribing of this pain medication. So she lost that provider due to that provider's, the view of the licensing board of that provider's prescribing as being overprescribing, unsafe prescribing practices. And the other providers that complainant mentioned, the nurse practitioner that, I think it was a nurse practitioner, someone else who was working in that office who was part of that prescribing practice, her license was also put under review. I can't remember if they lost their licenses or if they were just suspended, placed under review, told to stop engaging in those practices. And so she went to this new provider. Again, she had providers at this facility for other specialist things, went to this provider. And it is true that that provider is part of a statewide program that is working on patients who have been what in her view have been overprescribed this medication. Again, I'm going to say a lot of things from the perspective of the parties. I do not have a medical degree. No, this finding was not about whether or not the treatment was appropriate, whether or not complainant needed this medication or didn't need this medication, just whether or not the decisions made by her providers were discriminatory because of her disability. Complainant's claim, as she stated here, was basically that because they're using a program and they're targeting people who are on a certain level of medication, that was a policy that she wanted an accommodation from. In footnote 4, I discussed why I didn't think that was the appropriate legal analysis for this case, because as has been brought up, there are exceptions that you can be put on a higher dosage if your medical provider thinks you need to be. So there wasn't a policy necessarily that couldn't be the The policy was do these things unless. There's an unless built into the policy. So I didn't find that there was a policy in place that was that needed to be accommodated from, because if the doctor had had made an assessment that she needed the doctor wasn't prevented from putting her on a higher dosage if the doctor felt it was appropriate, or the nurse practitioner felt it was appropriate. So with regard to terms and conditions, I then had to decide whether or not the decisions being made, the medical decisions being made, were being made for non-discriminatory reasons, such as medical research, medical judgment, or whether complainant was being targeted because of her disability. And that's where I did not find that she was being targeted because of her disability. There was an issue that the practitioner saw with her medication based on her medical background. She made a decision about that the complainant disagreed with, but nothing about complainant's specific medical conditions or disability were a factor in that decision. I'm happy to answer any questions.
Commissioner, questions for Investigator O'Reilly? Okay, thank you, Jane. We have heard from the parties and the investigator. At this point, we'd be looking for a motion. There is one proposed finding. Commissioner O'Reilly.
Well, I may not get a second, but I would move that there are reasonable grounds to believe that St. Joe's Hospital and St. Joe's Internal Medicine discriminated against Brandy Stokes on the basis of disability.
Second.
I see.
Okay.
So that,
I know it's a little bit out of order, but can we ask you to explain?
yeah, I was
how you
gonna
came to
say,
that
can I,
conclusion?
yes, because I do know that doctors are looked at, I think it was, I do know that I used the word scrutinized, someone else used the word surveillance, and I think that's probably true. And I think that they, that as and I looked up the term legacy patient, and it is what I thought, that they had been prescribed before. They came in with chronic pain. I see this differently, I think, because pain is so subjective, and that, you know, one person's 2 is another person's 15, and, you know, that kind of thing. And I guess the fact that, according to the complainant, her condition so deteriorated when she was tapering. Well, ask me questions and I'll answer. I just, to me, it is not necessarily a medical standard of care, a medical decision. To me, that it's not necessarily that. It's extenuating circumstances that they are being surveilled, and legacy patients or long-term patients, when it was working, and the risk of death, I mean, yes, absolutely. There's overdosing, there's risk of death. On the other hand, there's also the risk of death if they're not being treated. Many reasons that can happen. So I'm sure I haven't articulated it as well as I want to, as well as I have in my head, but that's why.
All right. I'm not seeing a second, so we need another motion. Commissioner David?
I'll move we find that there are no reasonable grounds to believe the respondent unlawfully discriminated on the basis of disability, and the complaint should be dismissed.
Second.
It's still got a second, so only two possible motions, right? All right, moved and seconded. Any discussion?
Yeah, so I just want to respond to Commissioner O'Brien because I appreciate where you're coming from and I'm listening to everybody. There's more to this than I thought when I initially read it, right? I think where I'm at right now is there's a couple of different questions, right? And we need to be careful to tease them out, right? I was earlier focused on the medical standard of care, right? And I think that's going to be, as I said to complainant, it's going to be a significant hurdle for you to overcome at trial, because I do think in order to establish that there's discrimination here, you're going to have some testimony saying that this is not just somebody's medical judgment here at play, and this is somehow outside of the standard of care. Otherwise, I don't think anybody's going to believe it. But I think the second thing, and I think this is where the problem is even if she establishes that, which I think is going to be very difficult, what then is the evidence of discrimination? Where is the discrimination here? I mean, we've heard some things about the legislature and different policy issues and discussions, right? And I appreciate that, and I appreciate where she's coming from with that. And I appreciate the pain issue as well, but I don't see the discrimination. What I see is a policy disagreement, a treatment disagreement in terms of what's the appropriate dosage for anyone, what should the policy be, and in a broader sense, because it's been implicated, how do we deal with the opioid issue in general? I don't see discrimination in this particular case.
Julie,
that's why.
I think I'm sensitive to what you're saying too, the legacy patient that, it seems to be working, but these are differences in good faith providers making medical judgments that I just can't second guess. And say that provider looked down on this patient and said, "You're disabled, I'm tapering you," but not somebody that's not disabled. There's no connection to the disability in terms of what her medical judgment was.
So basically, I agree with what all three of you said. Totally sympathize and agree with Commissioner O'Brien's comments, but I can't tie it to a disability violation of the Maine Human Rights Act. I'd like to, but I can't see it.
I want to hear what Commissioner Sanders says, because he has expertise in this area.
Yeah, it's not within this commission's purview, nor do any of us, I think, none of us, I certainly don't. I'm not a provider, not a physician, an NP, not a licensee in the state of Maine. I don't have expertise to weigh in. Again, neither do we as a commission, nor is it our role on the medical decision-making that happened here, right? And the appropriateness of that medical decision-making. The complainant hasn't demonstrated a violation of the Maine Human Rights Act to the extent that the complainant wishes to continue this conversation. There are other appropriate venues to do that if she so chooses, for example, with the licensing boards in the state of Maine, to the extent she believes she has a cause of action that sounds in medical negligence. She certainly has the right to explore and pursue that. But again, those are all remedies that fall outside the purview of this commission.
I'll just, I'm probably not going to weigh people, but I will say that how I'm seeing it as discrimination is that her disabilities, have are being, well, I could articulate this better. I do think the fact that she is a legacy patient, and I do think that because it has gone on so long, I believe, again, not necessarily a standard of care. I think it's because the institutions and the practitioners are being surveilled, and it's not necessarily her disabilities is not necessarily the reason. And I believe because of the legacy patient, and because doctors are so conscious now, I think there's been a pendulum, and I think it's going to come back, but they're so conscious of not prescribing, and that doctor shopping, or they're being somehow patients are somehow being almost the assumption that they're doctor shopping or addicts or something like that. And I think that is, I'll leave it at that.
Any further discussion? All right, seeing none, the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
No.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
So the findings are no reasonable grounds. We thank everybody for their participation, and the commission will send a letter to the parties confirming the result.
Next case is Ryan, is 2472, Ryan Balzac, Mr. Walnut County. Recommendation is for finding of no patents on both counts of sex discrimination and retaliation, and we would hear from
Ms. Blazek, am I pronouncing your name correctly?
It's Blazek.
Blazek, okay, Ms. Blazek, you have 10 minutes. Do you want to reserve any of your time?
Yes, please. Can I reserve 2 minutes?
Sure, whenever you're ready, go ahead.
Okay, thank you. Okay, good morning, everyone, and thank you for your time today. Just to recap what this complaint is about, on May 5th, 2023, I was stopped by a man who was sitting in the hot tub while I was on duty as a lifeguard at the YMCA, and was told by the man I was not allowed to wear a sweatshirt to work and instead had to wear a bikini to work. I said gross, and the man continued to tell me 3 times in that interaction to wear a bikini to work, while he looked my body up and down and gestured at the length of my body with his hand and told me he thought my body would look great in a bikini. All while I was saying gross, ew, and I don't like being told to wear a bikini. The offending man continued to state the only reason he goes to the YMCA is to see nice bodies and people in bikinis, saying, quote, "It's what I live for." The man has admitted to saying everything I reported him as saying, and the YMCA has acknowledged this. There is no dispute over whether or not the man made those comments to me while I was working. The dispute is whether or not telling an employee to wear a bikini to work because you think their body would look great in a bikini is sexual harassment. The week after I reported the sexual harassment, my work schedule was changed without me requesting a change, without anyone telling me my schedule would be changed, and without me changing my availability. I went from being scheduled 18 hours a week to 8 hours a week. Since February, I had the morning shift and was paid a shift differential of $1 for working shifts before 8 a.m. After I reported sexual harassment, my schedule was changed to start work at 8:30 a.m. 8:30 a.m. had never previously been a shift start time. The man I reported for sexual harassment comes to the natatorium to sit in the hot tub every weekday from 6 a.m. to 8 a.m. The YMCA's only remedy for this event was to tell the man he made me uncomfortable. The YMCA asked the man to not make comments like that to me again. Those are the undisputed facts of the case. To speak on the relevant facts left out, as well as the factual errors in the investigator report, I'd like to start with 1B footnote 2. And this is also mentioned later in the report. Several college students did not return. The record shows this as I had previously submitted the schedule to support my case. One college student returned and took 2 morning shifts. The aquatics director took 3 morning shifts. Prior to my reporting of sexual harassment, I had 4 morning shifts a week. The aquatics director only works lifeguarding shifts when no one else is available to cover that shift. I was available to work the morning shifts, but I was not scheduled. This change occurred the very next week after I reported sexual harassment. This schedule change with the pay differential is adverse treatment brought on by my reporting of sexual harassment. The respondent will counter by saying they repaid me the money I lost from the schedule change, but that was only after I called them out on it. And I think this is an important detail to consider. Page 2, section 1 of the investigator report writes that the CEO told me to bring any questions about sexual harassment to the CEO or HR instead of talking about it at lifeguard in-service. That is not true. The CEO told me I could make an appointment with the YMCA's lawyer if I wanted to talk about sexual harassment. A relevant fact left out is that the aquatics director previously told me we would be discussing sexual harassment at the in-service, and that message exchange is documented. After I reported sexual harassment, HR began monitoring my conversations by asking aquatics director and assistant director to notify the CEO and HR anytime I spoke about sexual harassment, and this is documented. This monitoring of my conversations and the limiting of who I was allowed to talk about sexual harassment with would not have happened if I did not report sexual harassment. Talking about sexual harassment is a protected activity employees are allowed to engage in, and I was denied that right. Another relevant fact left out is the member, who was a YMCA donor, said the only reason he goes to the YMCA is to see nice bodies. The member does not exercise while at the YMCA. He only sits in the hot tub and sits in the 90-degree pool and positions himself to be in corners with full view of the natatorium. Knowing that the member's only reason for being in the YMCA is to look at nice bodies interferes with the lifeguard's ability to patrol the pool. I did not want to be under his gaze. The man making these statements and the YMCA acknowledging that the man made this statement is a relevant fact left out when considering the pervasiveness of the sexual harassment and how his comments and behavior affect all members of the YMCA and not just me. In section 8 of the report, I have a question. There's a line that says the respondent is not liable for members' conduct. So a question concerning the report's interpretation of the law. Does the membership agreement between members and the YMCA create a liability? Another factual error and relevant fact left out is I did not report the man who exposed himself 4 times to minor lifeguards to the police. The minor lifeguards reported that. I reported to the police about the CEO showing up to November in-service and telling me I was not allowed to talk about sexual harassment. I was concerned I did not have a pathway for reporting sexual harassment or retaliation at the YMCA, since I was told I was not allowed to talk about it with the aquatics director, and the retaliation I was facing was coming from the CEO, so I was unable to reliably report to him. I also think it's worth thinking about the community aspect here and the culture of how the YMCA responds to reports of sexual harassment. They dismissed my reporting and also dismissed my peers' reporting. And I don't believe the YMCA's response was effective corrective action. And I think if you were to poll the Waldo County community about this case, they would agree that the YMCA's response is out of alignment with their stated values. I also believe asking the man to watch a free 15-minute educational YouTube video about sexual harassment is reasonable. The YMCA refused to merely ask the man to watch the video. I did not ask for it to be a requirement to his membership. I asked him to be shown the video to support his education on the topic of sexual harassment in order to prevent him from using the excuse of, I didn't know what I said was inappropriate for a future event. A reminder here that a few months after I reported the man for sexual harassment, I reported him again for another inappropriate comment. So I disagree that the YMCA gave effective corrective action to my reporting, and I'd like to end my time here.
Commissioner, questions for Ms. Blazek? Commissioner Douglas.
Yes, good morning. So first of all, I just want to be clear about what happened here and how everybody in this room, I believe, is considering it. There's not a person, I think, within the sound of your voice that believes that the remarks by this man about you wearing a sweatshirt and what you should be wearing to work are appropriate. Nobody thinks that, I don't believe, right? I think the question for us is the appropriateness of your employer's response. And that's what we're sort of focused on. And so just to sort of hone in on some things that you said here, you know, it seems that the report says that your employer, who was a member, not another employee, you know, went and contacted this person and basically said, knock it off, right? Or whatever they said. Are we correct? Because I don't see any reference in the record. After your employer sort of reached out to this person, there were no more incidents of harassment, or are we incorrect about that?
Yeah, my employer told the man to not talk to me again. And so the man didn't talk to me again.
Okay. And so basically the gist of your complaint is that there was a response from your employer, but you felt like it didn't go far enough. Like, for example, you felt like the employer should have made this member watch a video on sexual harassment, or at least asked them to watch the video.
Yeah, a lot of the YMCA's policy is a focus on education as prevention for sexual harassment. So I thought it would be appropriate to have this free YouTube video. And I guess to answer your first question, I think I answered it incorrectly later. And so that this incident happened in May, and later in, I believe, November, I had knocked on a single.
I don't mean to interrupt you. I'm remembering that now that you're mentioning it, right? You knocked on the door. He didn't know who was outside. He says, come on in, right?
Yeah. And so I know that, like, he didn't know it was me. So, like, him saying that to me, like, he didn't know. But, like, my point is that the corrective action didn't correct the behavior, and that he just continued saying inappropriate comments at the family-friendly YMCA.
Right. I mean, was there any way for him to know who was outside the door with respect to that second incident?
No, you know, I was just knocking because I wanted to use it, and I didn't know if somebody was in there or not. You know, it was just being courteous.
I got you. So you're saying his behavior is generally inappropriate on that, not necessarily directed at you, but just inappropriate as you know, for the facility that you were at, as you say, this family-friendly YMCA.
I would say that. Yeah, which is why I gave that video recommendation.
Right. And then with respect to the early morning shifts, I mean, you've made a point that there weren't really a whole bunch of college students back, so they need to shift things around. Did they make that right for you? I mean, did they, you know, they fix your schedule? The report indicates that they did.
Yeah, I think the report says it was 1 week, but I think it was over 1 week. It was closer to 2 weeks, and they only changed it because I, like, called them out on it. I, like, remember very distinctly telling the HR person, I was like, all you did in response to my reporting of sexual harassment is fact check me and then change my schedule, because they called the man and he admitted to saying everything. And then the very next week, my schedule was changed to a shift that didn't even exist. We don't ever start at 8:30.
I'm with you. I understand why you raised that. Did they pay you for the money that you lost during that period of time where they changed your schedule?
They did repay me after I called them out on it.
After you raised the stink, basically, right? After you raise the stink, basically, right? Then they paid you.
After that, yeah. And I guess I'm just concerned that I worked with a lot of teenagers, and I don't think that they would know to raise that concern. And I don't think that everybody would know that you're not allowed to do that. And so I just don't think it's right that the employee has to call out the employer's behavior at every step. I think that they should just know to not change my schedule to accommodate the offending man's schedule.
I gotcha. Okay, all right, thank you. Appreciate that.
Any further commissioner questions? Yes, Commissioner David.
I'm struck by what you just said to Commissioner Douglas, that they did change it after you called them out on it, so that your complaint is that they're not that they had to be called out, that they're not educated enough, that they're not sensitive enough. I mean, we're talking about cultural changes in perceptions of inappropriate conduct, and as Commissioner Douglas says, we all agree that the initial conduct and the comments are inappropriate, and we're trying to change that. But you're saying that you shouldn't even have to tell your employer and call them out on it? I mean, they make it right. How much do you think that the Human Rights Commission can lead the cultural shift?
Yeah, I mean, again, I was concerned. I felt like a duty to report, just considering that most of the employees at the YMCA, especially the lifeguards, are teenagers and high school students. And I don't want them to get the impression that if they rightfully report sexual harassment, that they get their schedule changed. And that's,
well, I appreciate you doing that. It would seem to me that generation is pretty sensitive and pretty much leading the charge, but you think they're not.
Yeah. Oh, it's not that I don't think that about the coming generation. I just think that they don't know employment rules and employment law, and that if like the YMCA changed my schedule, which affected my pay because I was no longer eligible for the pay differential, I don't think that the high school students would know that that wasn't allowed. And I just don't want the YMCA.
And they restored the pay.
What's that?
They made it right and they did pay you.
They did, yeah, after I brought it up.
Right. And our standard is severe and pervasive.
Or pervasive.
I'm sorry, I keep doing that.
It's an important little word.
Severe or pervasive. And you think that this lack of response contributed to that being the case, that it was severe or pervasive sexual harassment?
Yeah, I am maybe like the response, but I was more thinking about the man's comment of saying the only reason he goes to the YMCA is to see nice bodies. And that is coupled with him he only stays in the hot tub or the 90-degree pool. He doesn't exercise at the YMCA. And during the investigator's report, this was brought up, and the investigator asked the YMCA staff if that's allowed, like if you're like required to exercise at the YMCA, or if you're just allowed to people watch. And the YMCA says that you are just allowed to people watch.
And you're the implied remedy that you want for that behavior, and for him saying that, the only reason I go is because I like to look at the nice bodies. You want him expelled. You want him prevented from membership.
Well, I first wanted him to watch the free YouTube video, just because he said that he was unaware of what he said was inappropriate, that he thought he was giving me a compliment. And so it just seems like education would have benefited him.
Okay, thank you.
Any other commissioner questions? Yes, Commissioner O'Brien.
Thank you. You just said something that I don't know that I picked up from reading the case. I just want to clear up. Are you asserting that your hours were changed to that particular 8:30 time because that's so that you would miss this particular member? Is that what you're saying?
That's correct, yes.
Okay, all right. Somehow I didn't. Thank you.
Any other commissioner questions? Seeing none, you will have about 2.5 minutes left when we come back to you.
Okay.
Attorney Snyder, good morning.
Good
Would you like to
morning.
reserve any of your time?
Yeah, I'll reserve a couple of minutes. Thank you.
Whenever you're ready, go ahead.
Sure. So, good morning. I represent the respondents in this matter, the Waldo County YMCA. At the outset, I just want to be clear about what's not in dispute, and Ms. Blazek said this as well. There's no dispute by the respondents that the comment made by this member was inappropriate. It absolutely was, and it was treated as such. I think that really the issue here sort of hinges on Ms. Blazek looking for a definition of what constitutes unlawful sexual harassment. And here, what she's reported is that there was an instance of discrimination based on sex and retaliation based on whistleblower protections. And just to speak briefly on this issue of whether there was unlawful sexual harassment, that's something that was addressed repeatedly and brought up repeatedly by Ms. Blazek throughout this entire process. She was offered the opportunity to speak with Waldo County YMCA's counsel about what the definition of unlawful sexual harassment is and whether her circumstances fell under that definition. And the conclusion that was reached by counsel for Waldo County YMCA, as well as the HR specialist that they hired to address this, was that this specific instance, while undoubtedly inappropriate, did not rise to the level of unlawful sexual harassment because it was not severe or pervasive. And that was communicated to her on multiple occasions throughout this process. Going into Waldo County's response to Ms. Blazek's report, the investigator correctly answered both questions in this case. Was there reasonable grounds to find unlawful sexual harassment? There were no reasonable grounds. Were there reasonable grounds to find retaliation for a whistleblower complaint? And there were no reasonable grounds for that as well. When Ms. Blazek raised concerns, those concerns were taken seriously, immediately, consistently, and with care. The record here shows that this was a single verbal interaction. There was no physical contact, no threat, no repetition after the YMCA intervened. In fact, management addressed the issue within minutes of the report. The member had no further interaction with Ms. Blazek, excepting one incident where the member was in a single-use bathroom and called out, not knowing it was Ms. Blazek on the other side. The investigator's conclusion here is well supported and consistent with the law. The YMCA's response independently satisfies its legal obligations. Ms. Blazek reported this incident the morning of May 8th. That same morning, she met with senior leadership, and during that meeting, she was asked whether she would be comfortable with management addressing the member directly and using her name. She agreed, and within minutes of that meeting, the CEO contacted the member, addressed the behavior explicitly, and made clear that it would not be tolerated. The member acknowledged the issue and agreed it would not happen again, and it did not. Management followed up with Ms. Blazek the next day during her shift to ensure she felt comfortable. At that time, she expressed appreciation that the issue had been addressed quickly and confirmed she was comfortable continuing to work. Again, this is not indifference. That's a demonstration of prompt and thoughtful response. Over the following months, the YMCA continued to engage with Ms. Blazek, responding to repeated follow-up questions, consulting with outside HR professionals and legal counsel, and even using her concern as an opportunity to strengthen their internal policies, enhance their training, and update the member code of conduct. This is above and beyond what the law requires, and is really an example of what we hope employers will do in the face of a sexual harassment reporting. So none of these instances establish unlawful harassment, and none undermine the investigator's conclusion that no discrimination was present. Turning briefly to the retaliation allegations, there's also no evidentiary basis to support that claim. The only alleged adverse action is this temporary scheduling issue. It lasted, as Ms. Blazek said, just over a week, and the record is clear. This occurred because of staffing adjustments. And when the student returned from college, this was something that had occurred in prior seasons, was adjusted, and then when Ms. Blazek brought it to the Y's attention, it was shifted back, and the differential she spoke of was paid to her. The other thing that was raised at one point in this investigation was whether or not this adjustment was made in an effort to prevent any direct contact between Ms. Blazek and the member who spoke inappropriately with her. And I'll just say on that, even if that were true, that is not retaliation under the law. And then I just briefly want to address this October 10th letter that Ms. Blazek wrote about in her statement of disagreement. This was a letter from the CEO of the YMCA to Ms. Blazek that essentially just stated to her that her personal views should not be misconstrued as the YMCA's views, that, you know, her personal views and the employer's views were different, and that while she should continue to speak freely, that basically those statements could not then be imputed to her employer. This was sort of an effort to cover themselves for any liability for statements that Ms. Blazek may have made to members or coworkers about what was going on with respect to her reporting. As far as whether this was addressed at the lifeguard training, it was made based on a consult. The decision was made based on a consult with the YMCA's attorneys and the HR consultant that it would not be an appropriate platform for the CEO or the aquatics director to discuss Ms. Blazek's sexual harassment reporting at a standard lifeguard in-service training, and that it would be more appropriately addressed in private to maintain not only Ms. Blazek's privacy, but the privacy of the member and sort of the integrity of that investigative process. So just, you know, to sort of sum it all up, the relevant standard here is not that a perfect action was taken, nor is the relevant standard that an employer must meet each of an employee's demands or considerations as far as what the employee thinks is the appropriate remedy. The standard here is prompt, effective remedial action, and the Waldo County YMCA met and exceeded that on every level. For those reasons, we would respectfully request that the commission adopt the investigators' findings and dismiss the complaint. I'm happy to take any questions. Thank you.
Commissioner David and then Commissioner Sanders.
Attorney Steiner, you just said that in regards to that shift change issue, that was made because of returning college students or something. I don't recall seeing that. I thought you would minimize that retaliation by saying, well, they quickly fixed it, they paid her the shift differential, no harm, no foul. But it seems to me that was a retaliation. Where is the evidence that it was just coincidental that it came after her complaint and that it had to do with college students?
So my understanding is that the way that the shift scheduling works is that employees indicate in an app when they are available or when they are not available. And this returning college student came in and was then being factored in for the first time in a long stretch coming back from college, adjusted his availability or her availability. I'm not sure which gender this person was or sex. And then when the aquatics director factored in that new person's availability, the schedule shifted, and that individual coming back from college was given some of those morning shifts.
Okay.
Commissioner Sanders?
Sure. Thank you very much, Attorney Snyder. Your presentation was very helpful. I'm curious about something that the complainant said during her portion of the presentation. And although it wasn't explicit in the report itself, and she may not have been explicit about looking for this as a remedy as well, I wanted to ask you about it, which is the complainant made a comment about how suggesting or intimating that appropriate member conduct should be a condition of membership at a Y. And I'm just curious if you can speak to that. Is appropriate conduct for members a condition of ongoing Y membership?
I know that, without, looking specifically at all of their policies, I know that the YMCA has sort of core values that they articulate to members. And that includes, respect, kindness, the sort of standard pillars that we would expect in sort of any community forward organization. And I believe that's what Ms. Blazek is referencing when she is speaking about, expectations of members. And again, I would say that that this was certainly out of alignment with those values. That behavior was out of alignment with those values, and that the CEO addressed that quickly, explicitly, and unequivocally, and said this behavior cannot continue, and that there were no additional instances reported beyond that with respect to this member.
Do you know, and this may be a question that's better for the investigator if you don't know, do you know whether as part of that discussion that the CEO had with this member, in addition to the CEO communicating the message that under no circumstances, right, shall you make any similar or the same kinds of statement to anybody in the facility, do you know whether the instruction also included, a sort of a transparent warning that to the extent that there was further conduct of the same kind, that it could very well lead to a revocation in the membership?
That I don't know off the top of my head. I apologize.
Okay. I'll ask the investigator that question as well. The investigator may know. And then just one more question for you. I think I heard you say in your portion of the presentation that in connection with this incident, right, the incident where this member made that highly inappropriate set of remarks to the complainant, that the Y hired an HR specialist to either investigate or respond to these circumstances. Did I get that right? And if so, tell me more about what was the impetus for hiring that person and what did that person do in connection with this event?
Yeah, so the Waldo County Y has an internal employee who manages HR on a day-to-day basis. When Ms. Blazek made her report, they engaged a third-party HR consultant externally as well to help facilitate not only the investigation, but to make sure that they continued to respond to her inquiries as appropriate, and to really take a look and make sure that their policies were as robust as they possibly could be with respect to sexual harassment, training, education, and kind of just really make sure that they were dotting all their I's and crossing all their T's.
Great, thank you. That's all.
Any other commissioner questions for Attorney Snyder? Okay, seeing none, you'll have 2 minutes when we come back to you.
Thank you.
Blazek, you have 2.5 minutes whenever you're ready.
Okay, and I'm just responding.
Yes, if there's anything else you'd like to add, you don't have to use the timer. It's yours if you would like it.
Okay. I guess the YMCA hiring the third party to talk about sexual harassment with the group happened, I think, in November, and I think the like the next coming weekend was the lifeguard in service. And so hearing the presentation from the third party about speaking about what sexual harassment is in the workplace further solidified my feeling that I did experience sexual harassment. And since the presentation was among the group and like the whole group heard, I sent a text to the aquatics director asking saying that I was confused that the third party gave this presentation speaking about what sexual harassment is in the workplace, and I felt like I experienced that. Why isn't it being treated as sexual harassment? Can we talk about it in the group? And the aquatics director responded saying, yes, we were going to talk about it. It was already on the agenda. And then at the lifeguard in service, the CEO showed up and he was not participating in the lifeguard in service. He was in street clothes. He was in and out of the natatorium, and he showed up and he told me I was not allowed to talk about sexual harassment with the group. If I wanted to talk about sexual harassment, I could make an appointment with the YMCA's lawyer. And he said that in front of all the other kids, so they all heard that. And that it just like interferes with like other people's reporting, and it just makes this intimidation that this is his behavior when you report sexual harassment in the workplace. And yeah, I just think that if other like Waldo County YMCA members knew that this happened, they'd be really disappointed in the YMCA. And they would just, I think that they would be like shocked that this is how they handled it, and that this man was just, you know, told that he can't talk to me again. And that was the end of it. And that's all.
Any commissioner questions for Ms. Blazek? Okay, seeing none, thank you very much. Attorney Snyder, you have 2 minutes if there's anything else you'd like to add.
I am all set unless anyone has additional questions for me.
Any further questions for Attorney Snyder? All right, seeing none, next we'll hear from Bob Beauchesne, the investigator assigned.
Good morning, Commissioner. Just to cover a couple of points, as both sides noted, it was undisputed in this case that Ms. Blazek was subjected to both unwelcome and inappropriate conversation from this particular patron. Nobody disputes that. She reported the incident the following Monday. This occurred on a Friday. Allegedly, within 10 minutes after her discussion with the CEO, he contacted the patron, had a discussion with him, and purportedly told him in no uncertain terms this was unacceptable conduct and that there would be repercussions if it happened again. In this case, it appears that that admonition was both effective and swift in that there was no further communication aside from this incident months later, which involved him allegedly using a single-use bathroom. She knocked on the door and he said something along the lines of, "Come on in." But at that time, he had no idea who was outside, whether that individual was male, female, or what the circumstances were. And even in that case, he was told that the more appropriate response in the future would simply be, this room is occupied or this room is being used. In this particular case, after she did make a report, she sent numerous emails to management specifically asking whether or not they determined this was unlawful sexual harassment. The responses were largely that this was sexual harassment and that it was harassment and based upon sex. But in this case, it was not severe or pervasive, as offensive as the conversation may have seemed. The patron apparently tried to explain it away, that he meant it as a compliment. And from what I understand, the CEO simply said, that really doesn't matter here. You've been told this is inappropriate, it cannot happen again. Whether or not that was by threat of expulsion or threat of some other type of discipline, in this case, it was effective in that the only other communication was when he was unaware that she was on the other side of the door. With respect to the retaliation, I was suspicious as well whether or not this slight change in the scheduling time was an attempt by them to keep them apart. They explained to me or suggested that this was because they had individuals that simply worked during the summer months that were away at school, and this was a way of simply melding those individuals back into the schedule without having to resolve that, respond in media, again, address the loss of finances and took care of that. So I was unable to discern whether it was a little bit of both or whether or not it was an attempt to keep them apart. But again, I can't fault them on that if that was their intent. Although in this case, it did result in the loss of temporary money because of that change in schedule. I really have nothing else I need to add to this case, but certainly I'm available for any questions you might have.
Commissioner, questions for the investigator? Seeing none, thank you, Bob. We've heard from the parties and the investigator. This time we are looking for a motion. 1, 2 proposed findings. I'm gonna be second guessing myself on this for the record.
Just sitting.
I move to take the investigators' findings as reflected in the report. 1, there are no reasonable grounds to believe that Waldo County YMCA discriminated against Ryan Blazek on the basis of sex. And 2, there are no reasonable grounds to believe that Waldo County YMCA retaliated against Ryan Blazek for engaging in MHRA and or WPA protected activity. And 3, the complaint should be dismissed in accordance with 5 MRS section 4612, subsection 2.
Moved and seconded. Any discussion?
Well, yeah, I mean, as a person in the community, this case, I understand why we're here. I understand why Ms. Blazek raised her complaint and she's carried it as far as she had. I mean, that the conduct by this member, just to reiterate what I said at the beginning, is disgusting. If they had said that to my wife or my daughter or any female that I know, any person I know, I'd be super offended. And I understand why she's super offended. I understand why she's been sort of raising this issue and had this issue on her mind as she goes to work and has to maybe encounter this person, whether or not he speaks to her or not, for all this time. I completely understand it. Unfortunately, under the law, I do feel that Waldo County's response was appropriate. And one of the things that was important was to hear the investigator say that there was, when they spoke with this person, there was a threat of repercussion. Like, if you do this again, something is going to happen, which I presume at some point would have led to him being expelled from the YMCA. Nobody said that, but I think as a member of the YMCA, there's only so many things you can do, right? So yeah, the facts of this case, I hate the facts of this case, but I don't think that this unfortunately meets the standard for discrimination claim under the Maine Human Rights Act because of the YMCA's response.
Any further discussion? Okay. Seeing none, the motion is to find no reasonable grounds on both recommended findings. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
So the findings are no reasonable grounds. We thank everybody for their participation, and the commission will send a letter confirming the results of the hearings.
We have only 2 more cases. Shall we keep going or do you want another break?
I think let's have a break. How are you all feeling about, do you want lunch or do you want to just power through?
I want to power through.
Yeah, I'm all for a break.
Okay.
I'm all for powering through after that.
So we'll take a
Bye.
break.
Agree with that.
5 minutes.
Hold on, our investigator got kicked out and is in the waiting room.
Okay, we'll be in session. The next case is Ezra Omaraglu versus UNE College of Osteopathic Medicine. The recommendation on a single allegation of discrimination is for a finding of no reasonable grounds. We will hear from complainant.
Right, Attorney Clifford,
Good
you
morning.
want to your time?
Yes, good morning. My name's Jim Clifford, and as indicated just now, my client, Miss Omaraglu, that's how you pronounce it, Omaraglu, wishes to make her statement and presentation independently on her own. I'm happy to answer questions, but the record, as everybody should have in front of them, is the complaint, the response, the reply, along with many supporting exhibits and statements and timelines and narratives. So that's there. I've read the investigator's report. My client is prepared to address the commission, and I'm going to put myself on mute for the moment. Thank you.
Good morning. Did you want to reserve any of that time to respond to the respondent's presentation?
Probably about a couple of minutes.
Okay, I will start you off with 8 minutes right now.
Thank you. Good morning, and thank you to the members of the commission for the opportunity to be heard. My name is Esra Merolo, and I am the complainant in this matter. I respectfully disagree with the investigator's findings. Upon reviewing the report, I identified omissions of key evidence, misstatements of material facts, and an improper application of the Maine Human Rights Act. Consequently, the report presents an incomplete and misleading account of the events. The report states that I was partially accommodated during my battle with metastatic breast cancer. That is simply not true. Not a single one of my 3 accommodation requests was granted. First, I requested flexible exam scheduling due to the unpredictable effects of chemotherapy. This request was denied. Instead, I was told to follow the same rigid policy as every other student, requiring doctor's notes and rescheduling exams on a case-by-case basis. At the time, my oncologist and treatment were based in New York City, where my insurance was accepted. This made compliance with that process even more difficult. But more importantly, requiring a student undergoing chemotherapy to meet the exact same standards as non-disabled students is not an accommodation. It is the absence of one. Second, I requested to attend small group case-based learning sessions remotely, just as is being done here. These sessions had already been conducted over Zoom in the recent past, and a classmate even offered to help facilitate the setup. Despite this request not fundamentally altering the nature of the service, it was also denied. Because of that denial, I was forced to travel 6 to 7 hours each way every other week between Maine and New York City for chemotherapy. I would drive from Maine to New York City on late Wednesday night after class, undergo hours of treatment on Thursday, and then drive back to Maine that same night, only to be expected in class at 8 a.m. the next morning, all post-chemotherapy. At times, I physically could not do it and missed a session. This was an unnecessary and unreasonable burden that directly interfered with my ability to participate equally in my education. The most serious issue, however, is the complete omission of key evidence showing disparate treatment. In May 2022, while actively undergoing chemotherapy and preparing for major surgery, I requested a deadline extension for the COMLEX Level 1 exam and permission to begin clinical rotations on time, even without a passing score. This request was denied, with UNECOM citing a rule requiring a passing score before starting clinical rotations. At that time, I accepted their decision. However, I later learned that during the same exact time period, multiple students in my same exact class, subject to the same exact rules, were allowed to begin clinical rotations without a passing score on the COMLEX Level 1 exam. Some took the exam 6 months after the start of their rotations. Some were even permitted to continue with their clinical rotations after failing the exam. That is blatant disparate treatment, that of which directly delayed my graduation date. The only meaningful difference between myself and those students is that I was undergoing cancer treatment and requesting accommodations. Under the Maine Human Rights Act, treating similarly situated students differently while denying flexibility to a disabled student is strong evidence of medical discrimination. Instead of addressing this, the report, as well as Unicom's responses, focuses solely on the same request I made the following year in 2023, when the rules were applied more uniformly to all students. But that shifts the focus away from what actually happened in 2022, the prior year. By omitting my 2022 request and focusing solely on the 2023 request, the report creates a misleading narrative that I was treated the same as everyone else, when I was clearly not. This falsely favors the position of Unicom. Finally, Unicom failed to engage in any meaningful interactive process. My requests were denied without discussion, without exploring alternatives, and without any good faith effort to reasonably accommodate my situation. I previously submitted a 26-page document detailing all aspects of this case, with supporting evidence for each assertion. Much of that information does not appear to have been considered by the investigator, which would have supported a finding of reasonable grounds. I understand the Commission handles many cases and is likely overworked, and I truly appreciate your time and effort. But the omissions and inaccuracies in this given report suggest that not all of the evidence was fully reviewed. All I am asking is simple, that all of the evidence be considered and that a decision be made based on the complete record and the law. I am not asking for special treatment. I am asking to be treated fairly and equally under the Maine Human Rights Act. When the full record is considered, the conclusion is clear. I had a documented disability. I requested several reasonable accommodations. All of these accommodation requests were denied without further discussion. And other similarly situated students, minus a disability, were treated more favorably. That is more than enough to support a finding of reasonable grounds. I respectfully urge the Commission to reject the investigator's conclusion and to review all of the evidence, not just some of it, before making a final and accurate decision. Otherwise, a grave injustice will occur. Thank you for your time and consideration.
Commissioner O'Brien.
Thank you. Good morning. I think it's morning. How often was this exam given?
It varied, sometimes every other week, sometimes every third week. It depended on the block.
Okay. I just wondered if it was months apart.
Yeah, it really varied.
Any other commissioner questions for Ms. Ameralu? Am I pronouncing that close to correctly?
Close enough, yeah. It's a hard name. My husband can't even say it, so don't worry.
All right. Seeing none, you'll have 3 minutes and 46 seconds when we come back to you.
Okay, thank you.
Attorney Schneider, do you want to reserve any of your time?
Sorry, I was just trying to come off mute. Good morning. I'm Ron Schneider for University of New England, and I'm going to be brief, but so I'll just reserve whatever I don't use, probably 2 or 3 minutes, if I even use up 7 or 8. So I just want to say that I believe that the investigator looked at this matter carefully, considered all of the evidence. We went through an issues and resolutions conference with final submissions by the parties with additional information. And I believe Investigator Morse came to the right conclusion. Student Dr. Ameralu was in fact treated similarly with respect to her peers in 2023, which is the time period that matters here legally with respect to the time period. There were 5 other students who were similarly situated who went into a support priority course that the university had created for people in her situation and their situation. She was actually treated differently in that she was accommodated, though, apart from those other 5, because she was allowed, based on her circumstance, to take the COMLEX level 1 in November. This support priority course was a year-long course. She was allowed to take it cut short because of her situation and her condition. And so she was allowed to take the COMLEX level 1 in November 2023 to move into her rotations in January 2024. The other 5 were not permitted to do that. And unfortunately, she did not pass the COMLEX level 1 in November. So that did not permit her to go into her rotations in January. She was also accommodated with the anticipated move into accommodations in New Jersey, which was something she asked for because that was close to her, where she was and close to her treatment. And that was accommodated at that time. So the issue with the pre-2023 in 2022, we do disagree with her that she was treated differently than similarly situated individuals. But that period of time, and this is what Investigator Morse indicated, and she's correct, that prior to, I think it was May 16th, 2023, that the events that took place before that, discrete acts, are time barred. And a denial of an accommodation is a discrete act. But I do want to make it the point that student Dr. Amerlu did, in fact, accept the accommodation that she was offered. She was offered an alternative. And the alternative was to, again, in 2022, was to take the COMLEX level 1 in November and to go to New Jersey starting in January 2023 and start her rotations there. And that she was so originally she had asked for 2 things. She had asked to extend her COMLEX level 1, which normally is taken somewhere in the neighborhood of June, before, so that people enter into a July 1, 2, 3, whatever that first day is, for their clinical rotations. She asked for the extension of the COMLEX level 1 exam and to start her rotations without taking that exam. She was denied the ability to take it, and this is in 2022, or denied the ability to go into her rotations without taking it and passing it. But she was granted the extension to November with the opportunity to enter clinical rotations in 2023 in New Jersey. Again, those are accommodations. I'm happy to answer any questions. I think the evidence on whether UNE engaged in the interactive process with her is very extensive, that in fact they did. The email communications between her and Student Access and the people at the College of Osteopathic Medicine, which we call UNICOM, is extensive, and they definitely engage in an interactive process. But I'm happy to answer any questions.
Commissioner, questions for Attorney Schneider? Seeing none, you'll have a little less than 5 minutes when we come back to you.
Thank you.
Ms. Amerlu, you have 3 minutes and 46 seconds. If there's anything else you'd like to add.
Okay. So Attorney Ron Schneider had mentioned that the investigator mentioned something about time barring, which in the report, there's no mention of that. Also, as far as all the accommodations that were denied, the accommodation requests that were denied, absolutely no alternatives were provided. That's also false. And he had mentioned that I had been given sort of an accommodation to attend clinical rotations in New Jersey. I did request that, but I was told that they would not be able to fulfill that, and that I would have to sort of fill out my rank order list of everywhere that I want to go, because there's about 16 different clinical sites that you rank, and you have to go through this process of a committee sort of figuring out everyone who goes where based on their rankings. And I luckily was granted New Jersey based on that committee decision, not because of the accommodation request. The accommodation request was denied. I got lucky in that case. As far as the 2023 requests, I shouldn't have been there because I had requested that in 2022. And similarly situated students were allowed to move forward with their year without taking an exam, and I was not. It's as blatant as that. I think that's all I have to say. Thank you.
Any commissioner questions for Ms. Amerlo? Commissioner Davis.
Ms. Zamora, you're saying that you were not allowed to take the exam because of unlawful discrimination because of your disability, correct?
Yeah.
On the basis of disability. And as I understand it, the respondent is saying you were not allowed to take the exam because they were tightening up and enforcing the policy. What is your response to that? The policy being that you had to have the exam before you could start clinical.
Right. In that same year where I made this request, my classmates in the class of 2024, I was in that same class of 2024, in that same time period, were allowed to move forward and were not subjected to those rules, but it was applied to me solely. So the only difference between these classmates and myself is my disability.
Who were the five people the other five students that the policy was enforced?
That was actually the following year.
In 2025?
So my initial request was made in 2022, and then I made a second request in 2023. In 2023, the rules were applied more uniformly. In 2022, they were only applied to me.
So your complaint is only about what happened in 2022?
It's both, because I should not have been in the position I was in 2023 had I not been discriminated against in 2022.
Thank you.
Any other commissioner questions? Seeing none, thank you. We'll move back to Attorney Schneider. Schneider, you have 4 minutes and 41 seconds.
Thank you. I think it's cleared up. I was just going to make it clear that there's the request in 2022, and with the alternative that I was suggesting. But I did want to make it clear that it's the requirement that you take the exam before you can go into a clinical rotation to treat human beings. Okay, so this is clinical site rotations where they go and they actually interact with real patients. And that exam, it's designed, it's not controlled by UNE, it's a national exam, but the point of it is to provide some assurance that somebody is actually ready to move forward. And that's why this particular exam exists. The other thing I just wanted to make clear, I think it is clear, but in footnote 2, Investigator Morse does indicate the date of May 16, 2023 as that 300-day mark with events, discrete acts taking place before it being untimely. Thank you. I'm happy to answer any other questions.
Commissioner questions for Attorney Schneider? Seeing none, thank you both. Next, we'll hear from Angela Morse, the investigator assigned to this case.
Hi there, my name is Angela Morse. I'm the investigator that was assigned to this case. My recommendation is that the commission find that there are no reasonable grounds to believe that the university committed unlawful discrimination under the MHRA based on disability. I don't have anything further to add, but I am certainly willing to answer questions.
Commissioner David.
Is there a legal issue? I guess I'm asking Barbara here about the statute of limitations and between 22 and 23 and that denial of.
The 2020, as Angela found, the 2022 claims are untimely.
They're untimely. And so the only thing that's properly before us is a claim from 2023.
Correct.
Okay.
Any further questions for the investigator? Okay, seeing none, thank you, Angela. And we've heard from the parties and the investigator. At this time, we are looking for a motion. There is one proposed item. You maybe look at the report. Commissioner David.
I'll move that we find that there are no reasonable grounds to believe that respondent unlawfully discriminated against the complainant. The complaint should be dismissed.
Second.
Moved and seconded. Any discussion?
It seems open and shut to me that is not discriminated against. The policy is being enforced. That's not unlawful, and is even-handedly applied.
Any further discussion? Being none, the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. So the findings are no reasonable ground, and the commission will send a letter to the parties confirming the results of the hearing.
And the last case is H 25, 434 Lawrence Foster versus Avesta. The recommendation is for no reasonable grounds on both counts, and we'll hear from complainant.
Yes, good morning, and thank you, commissioners, for taking my complaint. Can you hear me?
Yes.
Yes. Do you identify
okay.
yourself?
Yes, it's Reverend Lawrence Foster speaking.
Your screen name, it doesn't say that. That's why I have.
That's fine. I think
okay, I'm sorry.
Whenever you're ready, you may go ahead.
Okay. All right. Well, this case is based solely on my diagnosis and disability for religion, harassment, racial profiling, and loss of enjoyment in life, and my quality of life. I'm assuming that the commission board has the diagnosis that I sent in, and also I would like a transcript of the minutes from this meeting. And also, in the diagnosis, it does not say, but I went back for a follow-up with my neuropsychologist, and I have a 5th grade education, and I have a 10th and 11th grade reading and vocabulary. So the diagnosis, in the diagnosis, that proves this also. I need to know if I'm going to be evicted or not, because right now I have done nothing that shows good, I've paid my rent. There's no damage to the property. There's no illegal activity or unauthorized occupants. And also, I'm requesting a request for reconsideration, a right to sue letter, and looking for an attorney out of state, and file a civil complaint. And also, when it comes to the security cameras, there's a $20,000 security camera system on the premise, and I have a personal security camera. Right now, I feel this is a conspiracy, and also that the Wells Police Department has done no investigation whatsoever after Officer Gilman has left the
Mr.
police.
Foster?
Yes.
Please don't use the names of anybody who is not named in the complaint.
Oh, I'm sorry, but they are named in the complaint. I know it's
They're not named in this complaint, the complaint that we are hearing today. The only named parties are you and Avesta Housing Development Corporation.
Oh, okay. Let me see. For as far as I believe that the Board of Commissioners has has emails and also pictures of property that was stolen. Someone with a key, someone has a key to my car, someone has a key to my apartment. Even though the lock has been changed, the ongoing theft of my property is continuing. And with the security camera that I have that's personal, I'm the only one that's on the security camera. And also when it comes to Digital Sky, the proof is that the landlord, by letters and emails, the hacking, they've done nothing to take reasonable steps to prevent it. So I reserve the rest of the time for rebuttal.
Commissioner, questions for Reverend Foster? Seeing none, we'll move to Attorney Drury. You have 10 minutes. Do you want to reserve any of your time?
No, thank you. I don't think I'm going to take 10 minutes. Thank you very much for taking the time this morning. My name is Chris Drury. I'm the counsel for the respondent. I think we agree with the investigator's recommendation of finding of no probable cause. If you look at the allegations of the complaint, looks like the box checked for religious or religion discrimination has been checked. But if you look at the complaint, there's no actual factual allegations regarding religious discrimination. And we think that the investigator properly found that because there were no facts alleged, that there's no basis to proceed on that claim. With respect to the claim for physical or mental disability, the complaint alleges that Mr. Foster believes that other tenants or individuals have been breaking into his apartment and breaking into his car. He reported that to Avesta Housing. Avesta Housing took his complaints seriously. As he noted, there is a security camera and they viewed the footage. They could not see anyone entering Mr. Foster's apartment or his car. Mr. Foster has his own security system, and as he explained, he has not seen anyone entering his apartment. Avesta Housing changed the locks on Mr. Foster's apartment for free. And as Mr. Foster noted, he did make a complaint with the Wells Police Department. The Wells Police Department investigated and also could not find anything to substantiate his claims that there was somebody breaking into his apartment or breaking into his car. Based on that, there's really no basis to find that Avesta Housing discriminated against Mr. Foster based on his disabilities. Avesta Housing took the complaint seriously. They investigated. They couldn't find anything to substantiate the complaints. And there's also no facts alleged that would demonstrate that Avesta Housing was treating Mr. Foster differently than others based on his disabilities. So for those reasons and the reasons that the investigator found, we would ask that the commission find or accept the recommendation of no probable cause.
Commissioner, questions for Attorney Drury? Seeing none, you'll have 7 minutes and 40 seconds when we come back to you. Reverend Foster, you have 7 minutes and 2 seconds if there's anything else you'd like to add.
Yes. Attorney Drury, you said that this is alleged. It's not alleged. You have my diagnosis report. It's just not happening to anyone else here in the 20 people that live here. The police have not investigated. They have never showed up. I have a discrimination lawsuit against the Wells Police Department. They have not showed up at all. Detective Gasolin I made phone calls. He has never, ever showed up, and no police are investigating when it comes to the security cameras. It is still happening. I leave and my stuff is stolen. Someone has the key. I can't put anything in my car, and I box my stuff up in my apartment, and they're still stealing from me. So someone has the key, even though they changed the locks. I'm not lying about any of this. It's discrimination. It's against my disability. I'm an ordained minister, so I'm not lying in any way. Now, when it comes to the police department, the only person that investigated is no longer in the police department. Officer Gilman has left the police department. And when I spoke to Sergeant Aerosmith, Chad Aerosmith, and Officer Morris, George Morris.
If you continue to use the names of people who are not named in the complaint, I will mute you.
Well, Attorney Drury opened that up when he said to Wells PD.
They are not named parties in this complaint. You may not use their names.
Okay, fine. I apologize. So as far as the investigation, then as far as that's all I have to say for now, unless the commission board has something to add.
Commissioner, questions for Reverend Foster? Seeing none, we'll move back to, I apologize, I've lost my place. Attorney Drury, you have 7 minutes and 40 seconds left if there's anything you'd like to add.
I don't have anything further to add.
Okay. Any further?
I'm happy to answer any questions.
Any commissioner questions for Attorney Drury? Seeing none, we will next hear from Alex Brindley, the investigator assigned to this case.
I think it's officially afternoon, so good afternoon, everyone.
1 minute.
Yeah, but 1 minute. Good track. My name is Alex Brindley. I was the investigator assigned to this case here today. Based on my investigation and what the parties have provided to me, there's no evidence of theft, no evidence that the respondent treated him differently based on his abilities, and that they treated his reports of alleged theft differently. I don't have anything further to add. I stand by my report. Let me know if you have any questions.
Commissioner questions for the investigator? Okay. Seeing none, thank you, Alex. Thanks. We have heard from the parties and the investigator. We're looking for a motion. There are 2 proposed findings.
Do I have anything else I can add, or it's too late?
We're all set. We're all done with party presentations at this point.
I'll move to take the investigator's report as written and find 1, there are no reasonable grounds to believe that Avesta Housing Development Corporation discriminated against Lawrence Foster based upon religion, and 2, there are no reasonable grounds to believe that Avesta Housing Development Corporation discriminated against Lawrence Foster based upon disability, and 3, the complaint should be dismissed in accordance with 5 MRS 4612 subsection 2.
Second.
Moved and seconded. Any discussion? Okay, seeing none, the motion is to find no reasonable grounds on both recommended findings. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. So the findings are no reasonable grounds. We thank you for your participation, and the commission will send a letter confirming the results of the hearing. Yes. David?
You ready?
Yes.
Thank you.
Pursuant to MRSA section 405, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the rights and duties of the commission. A motion.
Do I have a second?
Second.
Any discussion? Right, seeing none, if you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. And as always, bear with us while we deal with the tax stuff. Meg, can you join the breakout room?
Loudly.
Okay, we're unmuted, we're on camera. I need a motion not to litigate PA 240015 King versus Greyhound or,
Case is not delivered.
yes, or H 250091
Oh,
Day
it should
versus
be.
Encino.
So moved.
Moved and seconded, any discussion? Seeing none, if you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner Ryan?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Yes. Okay. That concludes the meeting. Have a lovely week, everybody.
Thank you.
We stand adjourned.
We stand adjourned.